All right. Hello, everyone. Welcome to the show. It is 9:01, and we are watching the Ahmaud Arbery trial as it gets started. Welcome back. You guys should know who I am. I'm Nate the lawyer. And we are watching, I think this is like 8 or something of the Ahmaud Arbery trial. So if you're first time here, understand what we're doing here today. We're on verdict watch for the Kyle Rittenhouse case. So when that case goes to verdict, we will be watching that. We will switch over to that and want to see what happens. And we are proceeding with the Ahmaud Arbery trial. So let me just give you a quick background on the Ahmaud Arbery trial and let you guys know where we're at with that case. For the Ahmaud Arbery trial, the prosecution has rested its case. So um, it is done, right? So for the prosecution's versus this case, it believes that it's made its case why these 3 men should be convicted of felony murder. And I'm going to give you guys just a recap of everything of what this case is about. So how can we parse it out? Someone says they have no sound, but there isn't going to be any sound because it hasn't started yet. Um, so that's where we're at with this case today. Good morning, good morning, good morning, Eminem. Good morning, everybody. Good morning, chat. So this morning, I've started. I got a little PowerPoint for you. All right. So there's some things I want to there's some things I want to fix up from yesterday that I think are important. So to continue our analysis farther for today. First, well, first let me do the recap, and then during the recap, I'll clear up some of the issues that came up yesterday. So that's what we'll do. So I'm going to share a new screen, and I created a quick PowerPoint to help us out in this endeavor. I don't know how well this is going to help, but we will see. All right, view. Let's do full screen. Present. All right. So now for all of you, this is going to be a recap. So I want to make it very clear. This is going to be a recap of the Ahmaud Arbery case where we are at. Okay. Yes, I'm a Dolphins fan. Boom. So today we're gonna. So this is a recap of the Ahmaud Arbery case, and I want so everyone understands what the case is about and what the legal issues are with this case, right? So and hopefully this will help everyone understand what's going on. So this is the state prosecutor who's prosecuting the case. Now we're going to talk about their theory of the case. This is Ahmaud Arbery on in February when this is right before he was shot and killed by the McMichaels. Now the state contends that Ahmaud Arbery went into this house, and he was in there. He was trespassing. He was a chronic trespasser. So he's in this house and he's trespassing. And here's the picture of him in this house during that day. But the state's contention is that Ahmaud Arbery isn't the only chronic trespasser in this property. These children are also chronic trespassers. They trespass in the property and they take things in and out of this property. For instance, they took wood and things of that nature to build skating ramps. And the owner says that he did not, he didn't have any problem with the kids going inside in and out of there. But these kids were going into this property, into this house, and taking stuff out, right? So you have Arbery, and then you have these kids. Then you also have this other couple who went into this property on the same day. Again, I'm giving you an overview of the state's case, who went into this house the same day. So you have a white couple went in the same day, and many, 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 many other people went into this house in the same day. So we got Arbery, we got kids, we got white couple. Oh, thank you, thank you, thank you. RIP. Thanks for the dolphin money. So that's where we're at with the state's case. So the state wants to let the jury believe, wants to make us believe that Arbery was doing nothing different than all of these other people, right? This was just a simple trespass, and you can't hunt people down or chase people down for simple trespass, right? These kids, these children, this couple, and Mr. Arbery himself. There is no difference. So again, this is the state's version of events. Criminal trespassing, you don't get to do this whole escape thing, chase someone down under Georgia law. But so the state is maintaining that for burglary, you need this intent to steal, plus you need it to happen in the dwelling. And that gets you felony burglary. So if Arbery, if they can show Arbery had the intent to steal, then you had a dwelling, then you have burglary, which is a felony. So the state's contention is if you do have a burglary, then you can make a citizen's arrest based on you having this burglary aspect of it. So I can chase you down if you've committed a felony and conduct a citizen's arrest. But here's the kick. The state is saying that they don't have any evidence that Ahmaud Arbery intended to steal anything. So without that intent to steal element, you don't have burglary, right? They don't have any evidence that Ahmaud Arbery. They have the homeowner saying that, hey, he's been here all the time. I don't really think he's not stolen anything. We have no proof that he's stolen anything, so that we don't have a burglary. The state also attacks whether this is a dwelling or not. Says this is not a dwelling. Why? Because this is a house under construction. And if you can tell, even in their testimony, they keep saying this is a house under construction. This is a house under construction. This is not a home. This is not a dwelling. So those are the two things that the state is trying to convince a jury. There was no intent to steal, right? There's no evidence that he stole anything, or there was no evidence that he intended to steal anything. And number two, this was not a dwelling. So since you don't have intent to steal and you don't have a dwelling, then you don't have a burglary, right? That you don't have a burglary. So that's what the state's contention is. There was no burglary. This is not a burglary. This is a simple trespass. And because of these reasons, the state also says, well, since you don't have a burglary, then the McMichaels are not privileged to then conduct the citizen's arrest, right? Their citizen's arrest is no good because the burglary is no good, right? So if you don't have the burglary, then they do not have this citizen's arrest. So they can't now go back on and say, well, we were trying to conduct the citizen's arrest based on burglary, because they don't have any reasonable grounds to believe that this was a burglary. Think back to all these other people who are going in, right? You need more for burglary. And I also want to mention that the cops, they said that even if, and I think people need to understand that, even if they caught Ahmaud Arbery in the home, they wouldn't have been able to arrest him for burglary. They would have only been able to arrest him for trespass. Even arresting for trespass would have been suspect, because they would have had to give him a trespass warning. It was a whole procedure for that. So trespass is off the table, burglary is off the table, and because you don't have a lawful citizen's arrest, then that makes what they did essentially what's known as false imprisonment. So there was no burglary. There could be no citizen's arrest in this instance. So what happens is that if you conduct a false citizen's arrest, you've just committed false imprisonment, right? And that false imprisonment, and during that felony false imprisonment, you had now someone die, which was Arbery, and that's why these men are charged with felony murder for this false imprisonment of Arbery. And obviously the aggravated assault because they hit him with the car and all that stuff. But that's essentially what the state's case is. I'm hoping people understand it, but that's essentially what the state's case is. Here is the defense's case. The defense is saying, well, for intent to steal, the defense is saying, well, we can show that there was an intent to steal. Number one, something was stolen from the house, even though we're not sure if it was stolen from the house or not. Something was stolen. They believe they're saying something may have been stolen from the house. But for this intent to steal, the evidence they're showing is that here's Mr. Arbery going into this property on these separate occasions: October 25th, November 18th, December 17th, February 11th, and February 23rd. These are actual pictures from those days, still shots from those days. So the defense is saying, here's your intent. He's in there every night. He's looking around. What else is he doing there, right? Why would somebody be in someone else's house at 10 o'clock, right? What can we infer his intent to be, right? Is this just some criminal, some person who may be mentally ill who's just going into properties randomly, or is this a pattern of intent? Can you infer his intent to steal from all of these times that he's in the property? That is what the defense is trying to show us. That's what the defense is trying to portray. So for intent to steal, this is what they're showing. And the fact that something may have been stolen from the house, they're trying to infer that, yes, his intent was to steal, because who else would do this? Now, you may have been hearing about the jogging thing. What was he a jogger? Was he not? Now, it's difficult because the prosecution can't put on evidence that he was a jogger, because that then allows them to put on evidence that he wasn't a jogger. So they're both parties are staying away from that. But that's a question the jury's now going to have to resolve. If he wasn't stealing, then what the hell was he doing in there, right? What the hell was he doing in here? What was he doing, right? So The defense is just trying to say by inference, his intent to steal was there. Again, it's whether the jury can buy it or not, and that's why they hammered on this burglary aspect to it. Now, about the dwelling, the defense says that this is a dwelling, and the defense refers to the house as a dwelling, not as a construction site. The plaintiff, the people are saying it's a construction site, but the defense is keeps saying this is a house, this is a house, this is Mr. English's house, this is his house, because they said this is a dwelling. And since they believe that you have intent to steal based on this evidence, and you have this home, this dwelling, you have burglary. That gives, since they now can show that it's reasonable to believe that that Mr. Arbery committed this burglary or was in process of committing a burglary, they can now conduct a citizen's arrest because it is a felony. They were trying to arrest him for what they reasonably believed is a felony, and that these charges go away, right? Because they had a lawful right to try to arrest somebody who they reasonably believed, based on probable cause, that committed a burglary. That's the defense. So, and this is actually what they put up in there at the beginning. So that is what's the argument here in this case is. Did Mr. Arbery, if we have, well, the defense is hatching all its eggs in one basket, this burglary basket. And if they can show or get jurors to believe that Arbery was a burglary suspect, or it was likely that he could have committed a burglary, or reasonable people could believe that he committed a burglary, then they should be let off because they were conducting a lawful citizen's arrest. So that's the key point to this. Eric, oh, what's up, Eric? Are the contents of the house changing over time? Different tools. Well, the owner says that $2,500 was taken from the property, but he's not sure if it was taken from the property or if it was someplace else. But he says he lost $2,500. So there were things taken, and we know there were other things taken, like boards and things of that nature. But they were taken from kids. But there were things taken from this property. So I'm hoping people understand that. Second, so now I've given you guys what the crux of this case is about. Now, as you notice, I haven't mentioned race. I haven't mentioned it because obviously the prosecution is saying that this was based on that them chasing him down and killing him was based on race. The fact that they chased him and all that stuff was based on race because that's their theory of the crime. This was a felony false imprisonment. So a black man, they chased him down and killed him. Where the defense is saying, no, they had probable cause that he was committing a burglary and they chased him down to conduct a citizen's arrest. And that gave them the right to self-defense. Their right to try to detain him, and when he lunged at them, then that was it. So again, you can agree or disagree with these arguments, right? But these arguments they're making, and they're trying to say the evidence that they provided is based on this. Yesterday, there was a kerfluffle when we were talking about whether the plaintiff, not the plaintiff, whether the on February 11th, let me pull this back up. On February 11th, Arbery, and I'll show you this date. On February 11th, let me go back. On February 11th, this day, February 11th, Arbery had went into this home, and the police were called because it was the McMichaels who saw him going to the home. The McMichaels made the 911 call, and in that call, they said they believed Arbery may or may not be armed. The police arrived, and then over the 911 dispatcher, they told the police that Arbery may be armed. So the initial call for whether Arbery was armed or not was directly from the McMichaels. So the McMichaels said, hey, we see this guy, he might be going, and I'm going to play you the 911 call so you can see it for yourself, because this is going to be important. The reason why it's going to be important is because they're relying on it, saying we believed he was armed. That's why we took the gun, and that's why we took the gun and chased him down, right? Because we believed he was armed, and that belief was based on the February 11th incident. So let me play for you the 911 call that the McMichaels made on February 11th. This is was it 12 days before the shooting, so you can hear it. So let me play that for you now. And I'm going to cut this out and put it in a shorter video, but I wanted to make sure that we all are clear on the record. Now, at first, I listened to the testimony, but I missed this part, and I heard the 911 call, and I missed it, but because I was focusing on what the cop was saying. But this is going to be very, very. I think you guys need to hear this so we can all be on the same page. Let me see, which one is it? Is this one? This one? Jury sees this one. Okay. Sorry. This one. Boop. I'm going to expand this. So let's listen to the 911 call together.
He says in self-defense.
When I turned around and saw him and backed up, he reached into his pocket and ran into the house. So I don't know if he's armed or not.
Arbery's family has said he stopped at the construction site because he wanted to learn how to build a home for his parents.
So he's the one that actually said that he believed that Arbery was home on February 11th. And then the police went and had both the McMichaels and the other neighbors go armed, right, looking for Arbery with the gun. Now, Arbery's parents said that he was going into the house at 10 o'clock, 11 o'clock at night because he was wanted to see how to build a home for his parents. If you believe that, that's fine. You can believe that. But the reason why he was going into the home in the middle of the night in pitch blackness was so he can figure out how to build a home for his parents. That was what the family said. You heard it for yourself, right? That's not what I'm saying. That's what the family said. So if you believe that or not, it's on you. You know, you got to take the credibility of the witnesses. Do you believe that he was going into the house in the middle of the night in pitch blackness to see, to figure out how to build homes for his parents? I don't know. That's what the family says. So with all that said, hopefully that cleared up that confusion. Hopefully now you understand what this trial is about, and hopefully you understand where we're going with this. Now, this stream, let me see. I'm going to try to monetize this stream again. And we're going to hit. The trial has now started. They are now talking. So we are going back. I'm going to go back to today has started already. So I'm going to go back to the beginning. We're going to play it at a little faster speed, and we're going to go get into this to today's testimony. So where we're at today is the defense is putting on its case in chief. Hopefully that's what I just did for the past 10 minutes or so helps you understand what this case is about, where we're going, what each side has to prove, and how self-defense plays a role, how false imprisonment plays a role, how burglary plays a role. These are the arguments that are going to have to be the jury is going to have to decide. So let me now stop screen sharing that, and let's get into the trial testimony. Chrome tab.
Way to go about this is the state had indicated for a little bit of time to take a look at the demur on count 7. Is the state of any additional argument after reviewing the demur that had been filed on behalf of Mr. Bryan?
No additional argument. We stand on what we had originally filed and on the court's order on the demur to count 7, which is it.
We'll talk about that in a break. We're going to go over the motion to dismiss on the break.
Defend against, and therefore sufficient, and there's no reason to grant the demur.
I think there's a Brady violation. I think there's a serious Brady violation in that case. Oops, sorry. I think it's so serious. You see, I clipped this by the way.
For the court, before we get started, anything from the state? From Travis McMichael?
No.
Greg McMichael?
No, we're ready for our motion.
And from Mr. Bryan?
They got it.
Motion set. I'll just go around. Same.
Speak for both Greg and Travis McMichael.
At this time, on behalf of Greg McMichael, and I will speak for Travis McMichael with permission of co-defendants counsel, and invite them to add anything you may wish to add that does apply specifically to Travis that I may not mention, but I'm going to try to cover both in this motion for directed verdict of acquittal. And I'll start with the statute that applies to such a motion, and then go through the counts in the indictment that I think we have some argument to make. Regarding it. First, the statute. It's OCGA 1791A, which says where there is no conflict in the evidence and the evidence introduced with all reasonable deductions and inferences therefrom shall demand a verdict of acquittal or not guilty as to the entire offense or to some particular count of or offense, the court may direct the verdict of acquittal to which the defendant is entitled under the evidence and may allow the trial to proceed only as to the counts or offenses remaining, if any.
Yes, I'm muted. I muted
So
myself so
start
you guys
with
can hear me. So you guys can hear the trial.
Count
Sorry.
one, and let me get my indictment up here, which is malice murder. And to make this
I'll say
argument
it later.
for acquittal
I
on
forgot I
malice
muted
murder,
myself.
allow
Thank
me
you,
to
everybody. I
review
did mute myself.
initially what the elements of that offense are, and then talk about the evidence in the case. The statute, of course, is 1651 A and B, and 16.5.
Yeah, I unfortunately forgot to unmute myself. So just to let me know, what's going on now is the defense is asking for the judge to dismiss the charges because they're saying the state did not prove their case. So they're going through the charges and saying, hey, if you believe everything the state has put forward, we still win because the state has not proved its case. Very sorry about that. So that's what we're listening to right now.
5(1)(a) says a person commits the offense of murder when he unlawfully and with malice aforethought, either express or implied, causes the death of another human being. So starting with just subsection A, malice, of course, in Georgia law means a specific intent crime as opposed to a general intent crime. And in a specific intent crime, the subjective desire of the defendant is to bring about the exact illegal consequence that his action is intended to produce. So in a malice murder count, that means that that malice means the defendant has the specific intent to commit an act that the cause of which is the death of another person, and that result was the desired result. It was not an unintended consequence, as we'll see is the case with felony murder. So malice, that sort of specific intent, can be shown in two ways by proof, and that's subparagraph B in 1651. And that paragraph indicates two types of proof of this malice, the specific intent. Of course, I always mention that as a definition of malice because it's certainly confusing to jurors, but that's a different issue for later when we talk about charges. But it means no intent, no ill will or hatred, of course, but it's just a specific intent. Two types. Express malice is that deliberate intention unlawfully to take the life of another human being, which is manifested by external circumstances capable of proof. Now, case law indicates that would be things like verbal threats, lying in wait, the kind of circumstances or actions for which the state can produce evidence that says this person had expressed malice. It's out there in the world for us to see it. We can hear it. We can determine it from the circumstances in which the killing occurred. The other type of malice, much more sticky, is malice shall be implied where no considerable provocation appears and where all the circumstances of the killing show an abandoned and malignant heart. So to further define that type of malice, I need to go to a different place here in my notes to look for a definition of implied malice in our law. What we're looking for is that specific intent to kill where there are no external circumstances capable of proof, but inferences must be made. It's implied. And first of all, you have to find that there's no considerable provocation, which would be, say, voluntary manslaughter. And there's no other justification for it. And then in one of our cases under Georgia law, which is Parker v. State, and I'll get the site here, 270 Georgia 256.
We're catching up, though. We're catching
case.
up. So
essentially in Parker, the court tries to define that poetic metaphor we find in the implied malice sentence, which is the abandoned and malignant heart. I find it of interest that there are only 4 states left out of 50 that use that phrase in their definition of murder, abandoned and malignant heart, having its roots somewhere in the dark recesses of medieval English, but here it is still in Georgia, Idaho, Nevada, and California, the other 3 states that still use that phrase. And so Georgia, in attempting to say what it means, says that it's a reckless disregard for human life. And Justice Hunstein in Parker v. State tries to give some sort of definition for it. It's not a substitute for implied malice. That is, reckless disregard is not a lower mental state or lower standard of proof. It's not equivalent. It's As she says in this opinion, a special concurring opinion, she says the difference between instructing a jury that a presumption of malice may arise from reckless conduct, and this is for malice murder, and instructing them that reckless conduct and malice are equivalents that can be substituted for one another is not just a matter of mere semantics. A jury is entitled to be instructed how to determine a defendant's state of mind based on the evidence adduced. It is not entitled to be instructed that a lesser mental culpability may be substituted for the required higher mental culpability. And then she goes on to criticize the charge given in that case in Parker. But what it comes down to, and it's even cited later in a U.S. Supreme Court case, actually it was a case earlier than Parker, and also an attempt by Justice Brennan to define it. And the case is Arave, R-A-A, I'm sorry, let me start there. A-R-A-V-E, Arave v. Creech, C-R-E-E-C-H, 507 U.S. 463, a 1993 case. Justice Brennan wrote this: homicides committed without considerable provocation or under circumstances demonstrating an abandoned and malignant heart, a term of art that refers to unintentional homicide committed with extreme recklessness. And then I just use ellipsis there because he goes on to another matter. But examples given would be, say, somebody shooting a gun into a crowd of people. You aren't intending to kill any specific person, but you certainly know by that reckless act somebody will die. Or driving a car into a crowd at a protest rally. Somebody's going to die. This could be an abandoned and malignant heart. So that all aside, now the facts of our case, going back to the standard of 1791A, where directed verdicts premised upon no conflict in the evidence and all reasonable deductions and inferences therefrom. In this case, the state's case in chief, which we've just now heard for the last week and a half, the express malice does not seem to be there. Speaking about Travis McMichael in particular, he's not saying anything or doing anything that could be provable by external circumstances to be express malice. And as we've all seen in the video, the shooting doesn't occur until he and Ahmaud Arbery are locked up in mortal combat, hand to hand, face to face, and in contact with one another with a gunshot wound that's fatal, that's close contact or near close contact, 1 to 3 inches away. Now, none of that is in dispute. There's no conflict in the evidence there. Obviously, the issue that we expect will go to the jury is whether that was an act of self-defense or whether it's some felony murder. And there are counts in here that address that. There is a pair of counts that talk about using a shotgun as an aggravated assault, which results in the death, and that's felony murder. Those are two separate counts in this indictment.
So he's giving up.
It's always interesting too that malice murder added in the
and
same
sa-
case
and
with felony
challenging
murder,
the malice murder.
while not legally inconsistent. And of course, George has done away with the concept of legally inconsistent verdicts. Is somewhat logically inconsistent. When you ask a jury to consider finding a defendant guilty of malice murder based on proof you think you have, if you're the state, that he specifically intended by his act to cause the death of the person who died, and at the same time argue to them, but hey, also consider that he used a shotgun in an aggravated assault without malice, as the felony murder statute says, and the unintended consequence of that aggravated assault was the death of another person. Therefore, it's bootstrapped up into felony murder. So that is the argument against count one under 1791A as a count that should not be presented to the jury because there is no conflict in the evidence. All of the reasonable deductions and inferences from the evidence do not support a finding by a rational trier of fact that express or implied malice have been exhibited here in the act of shooting Ahmaud Arbery. Now, I can go on to each of the other challenges in turn or stop. The second challenge is to the combination of counts 5 and 9. And let me get my indictment back up. Count 5 charges felony murder premised upon count 9. Of course, we know that felony murder, and I'll get the definition of that, is in 1651C. A person commits the offense of murder when in the commission of a felony, he or she causes the death of another human being irrespective of malice. So we can forget all of what I just said about malice because it doesn't apply here. The state would have to prove the underlying felony and then show a causal connection, proximate cause between that underlying felony and the unintended death without malice. In this case, count 9 is the criminal attempt to commit a felony, namely false imprisonment, on, let's see if it says it in here, Burford Drive.
So the state's
Count
contention is
9, then, as we
they
know,
were trying to
is
falsely
the
imprison him,
allegation
and they
that on
killed him.
Burford Drive,
So that's what
the
gives you
beginning
felony
of the
murder.
encounter with Ahmaud Arbery, that Travis and Greg McMichael, along with Roddy Bryan, but I'll leave his lawyer to argue his case here, but that Travis and Greg McMichael, using their Ford F-150, attempted to commit the crime of false imprisonment. And then they combined that with count 5 to say that that's a felony murder premised upon that attempted felony on Burford Drive. Well, the causal link between the attempt to falsely imprison someone 3 or 4 minutes before shooting them with a shotgun is just too tenuous to support, under the proximate cause analysis, a felony murder charge in count 5. I'm not saying that count 9 can't stand and be presented to the jury, but when you combine it with count 5 as the underlying felony for felony murder, what we're facing then is a complete lack of a causal link. I mean, you can add several links to get to Holmes Road, where the shooting occurs, but there is nothing about the attempt to false imprison Ahmaud Arbery on Burford Drive with a pickup truck, particularly Travis McMichael's Ford F-150, and his ultimate death on Holmes
But they're
Road.
saying that the false imprisonment had
if
occurred
you
earlier,
try to do
and
it
it's not,
by
and it wasn't the
party to
causal
the
link
crime,
of the
16-220,
murder that
and connect Travis and Greg McMichael to William Roddy Bryan, as that count does, because it also names him in count 9, names his truck, his Chevy Silverado, in count 9, and then connects them both back to count 5 for felony murder. But 16-220, party to the crime statute, I'll read, it's not long. Every person concerned in the commission of a crime is a party thereto and may be charged with and convicted of commission of the crime. B, a person is concerned in the commission of the crime only if he, 1, directly commits the crime. And here we're talking about directly commits the crime of criminal attempt to falsely imprison Ahmaud Arbery on Burford Drive. And he didn't, that is, Travis and Greg McMichael didn't directly commit that crime with a Chevy Silverado. And then 2, intentionally causes some other person to commit the crime. That doesn't apply here. No one's causing anyone else to commit any crimes. 3, intentionally aids or abets in the commission of the crime. That is, proof that Travis and Greg McMichael are intentionally aiding or abetting Roddy Bryan in the commission of the crime of attempting to false imprison Ahmaud Arbery on Burford Drive. And then finally, intentionally advises, encourages, hires, counsels, or procures another to commit the crime. So as the evidence was produced here in this case, Roddy Bryan saw the white truck and saw Ahmaud Arbery, made some driveway assumptions, according to Ms. Dunikowski, and then went and got in his truck to do what he did. But as we heard, he hollered something that the McMichaels did not hear. The evidence from the state was uncontroverted that whatever he said, there was no indication, no evidence whatsoever that the McMichaels heard it. There was no phone communication of any kind between either McMichael's phones or Roddy Bryan's phones. In short, there was no coordination. There was no participation, no planning, no intentionally aiding and abetting, or intentionally advising, encouraging, and so forth between the 2 McMichaels and Roddy Bryan on Burford Drive, where count 9 concerns my argument here. So the criminal attempt to commit false imprisonment, if that arguably occurred by the McMichaels with their F-150 on Burford Drive, fails to support count 5's felony murder because of the tenuous causal link, approximate causal chain that's just not going to reach. And secondly, if it's a party to the crime theory, there's no evidence at all that there was any participation, intentional, and that's a key word in the party statute, between the McMichaels and Roddy Bryan on Burford Drive. So that's my directed verdict argument to count 5, and I make it in connection with count 9. And yet I am conceding that count 9 could survive a directed verdict and be presented to a jury. There is a conflict in the evidence there about what the McMichaels were doing on Burford. Obviously, we're saying that excuse me, that they're attempting to make a citizen's arrest. The state says they're attempting to do a false imprisonment. That's a legitimate jury issue. But connecting it to count 5 felony murder.
So if you guys are unclear about what I was saying before, he's saying the same thing I just went over
here under the motion for directed verdict. Acquittal will be the combination of counts 3 and 7. Again, count 3 is a felony murder count, and it refers to the allegation count 7. And when you go to count 7, the argument there is that the defendants committed an aggravated assault with a Ford F-150 and a Chevy Silverado, which they allege are objects, devices, and instruments which, when used offensively against a person, are likely to result in serious bodily injury, contrary to our laws.
So
but then they connect it to murder
ran him
in
off
count
the
3.
road with the truck.
Again, However, the trucks were used in this case by the McMichaels. The trucks were used, yes, to attempt to detain, to block in, to trap Ahmaud Arbery. But again, the argument here will be for the purpose of citizen's arrest, not for the purpose of falsely imprisoning him or assaulting him with a truck. But more than that, that would be a legitimate jury issue. In
I'm just stopping it just for one quick second. The reason why my mic is a little down, is a little low, is because their audio today is better. Because their audio is really low some days and really good some days. So I've turned my audio up. Hopefully you can hear me. I'm trying not to talk over him too much because I definitely want you guys to hear the arguments. But if you guys can hear me, just let me know.
Count 7, but in count 3, neither truck was the causal link in the death of Ahmaud Arbery. It was the means by which to get to the place where the death ultimately occurred, of course. It was the conveyance in which the defendants rode. But the truck itself did nothing to cause a serious bodily injury or death, at least the Ford F-150. And this is not alleging in count 7 that Ahmaud Arbery received some injury when he encountered Roddy Bryan's truck on Burford Drive. That's not alleged in this indictment anywhere, even though there's some evidence of contact between him and that truck on Burford Drive. This count is actually not saying anything about that, but connecting it back to count 3, felony murder. So it's the same problem as we just had in counts 5 and 9. It's a failure of a causal link, no proximate cause to show that the truck is connected to the murder in a causative way, and the same with party to the crime. The other thing this combination of counts does, it doesn't say whether this aggravated assault with the truck is occurring on Burford Road or Holmes Drive. We're left to guess which it is. It simply does not specify. Now that's a demur type issue, and that may have been addressed earlier. But here, for directed verdict, if the allegation is that the felony murder occurred on Holmes by use of the truck on Holmes, well, the undisputed evidence in the case is while the truck got driven to Holmes Drive, when we see the video, it's undisputed that the truck is parked, the driver is out of it, the truck is not moving, and it bears no connection at all except as a device around which the defendant stood, one Greg McMichael in the back of the truck, Travis out of the truck, and Ahmaud Arbery going around the truck. So the truck is not a causal element in the death of Ahmaud Arbery, and therefore count 3 should be directed as a verdict of acquittal for the defendants. Count 4 and 8 are connected. 4 is felony murder, referring to the allegations in count 8. Count 8 is the false imprisonment allegation, this time on Holmes Drive. And Holmes Drive, of course, is the final.
Now, there's been a word that's been mentioned a couple of times that I want you guys to also be familiar with. It's demur. And essentially what they're saying is that it's the so what, right? It's literally, if everything the plaintiff is usually, but if everything the prosecution is saying is true, they don't win, right? So that's what they're saying. They're saying everything that, and you'll hear him keep saying the demur issue. He's just saying, so what? If they say everything they're saying is true, they still haven't proven their case. So that's essentially what that means.
Place where the events transpired and the tragedy occurred. But this count 8 alleges that on Holmes Drive, using the 2 pickup trucks, the 3 defendants in concert with one another as parties to the crime, falsely imprisoned Ahmaud Arbery, and then the shooting occurs, and they make the causal link back to count 4 for the felony murder charge. But again, the evidence in the case was that there was no place on Holmes Drive where the truck was used to block in Ahmaud Arbery. Where the truck is finally parked, as Agent Dial testified yesterday, I believe, under cross-examination with Kevin Goff, he conceded that there were escape routes. There were places Ahmaud Arbery could have chosen to run through yards, across a yard and onto Satilla Drive if he had chosen to. So how one can be falsely imprisoned when the case agent is testifying under oath that he could have kept on running. The truck itself did not impede his decision to turn right and run across this yard onto Satilla Drive and continue down Satilla Drive until he left the neighborhood, or until he encountered the police, which we also have heard with undisputed evidence was on Satilla Drive when the shooting occurred. So he would have run into a police car at the very least, and then possibly Matt Albenzi if that police car was not where the undisputed evidence says it was. So again, count 4, felony murder, should fail because it's based on count 8, which count 8, it's fair enough to send to the jury. It's a disputed allegation, but count 4 can't be supported by it. Finally, counts 2 and 6 are connected, and our motion applies to them in this way. Count 2 is a felony murder, this time premised upon count 6, and count 6 is the allegation of aggravated assault with the use of a shotgun, a firearm, a deadly weapon, to wit, a 12-gauge shotgun.
So just in case everybody doesn't know, he's attacking all the felony murder
the evidence has come out
charges.
that Travis McMichael pointed his shotgun at Ahmaud Arbery on 2 separate occasions. There's been evidence presented by the state that as Ahmaud Arbery is running towards the back of the pickup truck, on the driver's side of the truck, Travis McMichael raises his shotgun, and then he lowers it and moves to the left front quarter of the truck as Ahmaud Arbery makes a couple of weaving maneuvers and then comes around the right side of the truck, and then the gun is raised again, and this time discharged, and those shots are what were fatal to Ahmaud Arbery. The count does not specify here in count 6 which of those 2 gun raisings is the aggravated assault. Certainly the first one, where no discharge occurred, could not therefore have been the cause of death, and it could not support count 2 felony murder since there was no discharge of a deadly shot from the shotgun. And because the count doesn't specify, applying a rule of lenity, this should be read as applying to that, because that by itself could be charged as an aggravated assault. Had the case stopped right there, had Ahmaud Arbery stopped in his tracks, and the state had chosen to say, well, this is no citizen's arrest, this is just a garden variety aggravated assault. You're pointing a shotgun at somebody for no good reason. You didn't discharge it, you didn't kill him, but it still could be charged as an aggravated assault. Well, it certainly couldn't be ever, under those circumstances, the underlying felony for a felony murder if the guy was still alive, if no shot had been fired. So that aggravated assault, though, is still in play. It's been put in evidence. It's not charged in the indictment, or is it? We can't tell from count 6, because count 6 only refers to one act of aggravated assault with a shotgun. And I guess the jury will be left to presume that it's the second pointing that results in the shooting, which results in the death, which results in the felony murder of count 2. Those are my arguments, Your Honor, for a directed verdict on counts 1, 2, 3, 4, and 5.
Thank you, Judge.
Woo. They want
So
to
we'll address that motion from the state, and then we'll get Mr. Bryan's motion.
Thank you, Judge.
let's see how she combats
OCGA
it.
1791 is the statute that governs directed verdicts. And there's also case law out there that, of course, the court is to view all the evidence presented at trial in the light most favorable to a guilty verdict and ask whether any rational trier of fact could have found the defendant guilty beyond a reasonable doubt. So that includes, Judge, not just direct evidence, but circumstantial evidence as well. In this particular case, all the defendants have been charged in this as a party to the crime. And of course, we've got directly committing the crime and then helping, which is intentionally aiding or abetting in the crime. And then we've got intentionally encouraging someone to commit the crimes. So we've got all of that charged together. Looking, of course, at count 1, malice murder. You may also find malice when there does not appear to be significant provocation and all the circumstances of the killing show an abandoned and malignant heart. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in an instant, and instantly a fatal wound may be inflicted. That, of course, is the current pattern jury charge 2.10.10 on malice murder.
So essentially, I just want to let everybody understand what she's saying, is that the defense is trying to say, well, I actually lowered it to 1.25 so we can catch up to the trial. So what essentially she's saying is that the defense is saying, well, there was no malice because because of this time length, right? There was so much time, and this murder kind of happened in an instant, so there's no malice. But the statute and the law says, well, malice can happen in an instant. And think about this. Think about if somebody who is arguing with someone, and that person says, well, I just slept with your wife. And in that instant, that person says, well, pulls out his gun and says, I'm going to kill that person, kills that person right then. Well, the malice, so that occurred right there, boom, at that time. So you don't have to prove that there was this long drawn out plan. It could just occur because the person is mad in that moment. And that's what she's saying. The law does allow them to argue that this malice happened as soon as he pulled the trigger. Just so we can all understand what she's arguing versus what they're arguing.
In this particular case, there isn't significant provocation. Mr. Arbery ran away from these men for 5 minutes, tried to get away, and was being forced down the street by Mr. Bryan in his dark pickup truck, accelerating towards him. He
No,
tries
you're
to go
talking about
around
malice.
Travis
But
McMichael. Travis
premedita- works
McMichael
with
steps out into the
premeditation,
street,
too.
blocking the street, pointing a shotgun at Mr. Arbery, and Mr. Arbery tries to go around the passenger side of the vehicle. Travis McMichael traps him and tracks him with that shotgun up to the front of the vehicle and basically encounters him right there. He's so close that Mr. Arbery, he passes this. He is so close that when he does this, he's instantly shot. Instantly shot.
This is
The video
this
itself
also is going
speaks
to be
for
her
itself.
closing argument.
There
This
is
her closing
that
argument.
much time, and that shotgun blast goes off, and Mr. Arbery shot point blank. The trajectory was, as you saw from the medical examiner, right here, straight through. That's where the shotgun pellets are. That's where that injury is. So at this point in time, we have met the burden to prove no significant provocation except Mr. Arbery coming around the front. Medical examiner talked about fight or flight. And I understand the defense is going to argue, well, it's the victim's fault. He should have kept running. It's the victim's fault. He shouldn't have been exhausted. It's the victim's fault. He shouldn't have gone to defend himself. It's the victim's fault. He had all kinds of options and alternatives in the face of their 5-minute attack on him, and therefore it's his fault.
She's
But that's
saying
not
that
what the
she's
law
blaming
is.
the victim,
law is
blaming the
about
victim. She's
the
doing a very good
defendants
argument.
doing a 5-minute attack that eventually resulted in malice murder. How do you see the malice here? Abandoned and malignant heart. You take a shotgun, you point it at somebody, you track them around as they try and run away from you, and when they turn on you, you immediately fire and shoot.
Boom.
The state asks you to deny the directed verdict for malice murder
I think she's got the better one of that argument.
for Travis McMichael and
It'll be
also
interesting,
for
though.
Greg McMichael. He is charged as a party to the crime. Greg McMichael had his .357 Magnum on him. He is also yelling at Mr. Arbery. We know that he previously had threatened Mr. Arbery with stop or I'm going to shoot your effing head off. So he'd already told this man, I'm going to execute you if you don't stop. So at that point in time, we've got Mr. Bryan coming forward. He sees the shotgun. He sees it pointed not only at Mr. Arbery, but it's actually pointed at himself because he's right behind Mr. Arbery. And he doesn't do anything. He doesn't stop. He doesn't slam on the brakes. He doesn't yell, oh my God. He doesn't swerve immediately out of the way to get off the road into a ditch to avoid the shotgun. He keeps going. He keeps accelerating. He keeps driving Mr. Arbery toward the man with the shotgun,
Not
thus
if they're
aiding
chasing you.
and abetting
Not if they're
intentionally.
chasing you. If they're chasing you, then you charge them.
Arbery
You're not
having to
prov-
run towards a
that's
man
not
with a
provocation.
shotgun.
In
Mr.
Rittenhouse,
Arbery could not
it
turn
was, but
around.
here, that's
Mr. Arbery
not.
could not run away back because
Rittenhouse didn't
Mr.
wasn't
Bryan
chasing them.
is accelerating toward him with his black pickup truck. Therefore, he is also a party to the crime of malice murder because it shows an abandoned and malignant heart on Travis McMichael's part and aiding and abetting in that by both the defendant, Greg McMichael, and Mr. William Roddy Bryant. Bryan. With regard to felony murder specifically, as the court is aware, felony murder must have directly caused the death or played a substantial and necessary part in causing the death. This, of course, is from our new jury charges 2.10.20 on felony murder. And in this case, all 4 of the underlying felonies played a substantial and necessary part in causing the death, because without those 4 felonies, Mr. Arbery wouldn't be dead.
Mm-hmm.
So we've got our old-fashioned but for, and that's what we're talking about here. Played a substantial and necessary part in causing the death. But for these actions, Mr. Arbery would still be alive. So when we look at, specifically, I'll take them in the order Mr. Hogue went. We're talking about count 5 felony murder and count 9, which is criminal attempt to commit false imprisonment on Burford. The indictment reads, in violation of the personal liberty of Ahmaud Arbery, did unlawfully chase Ahmaud Arbery through the public roadways of Satilla Shores neighborhood in pickup trucks.
Unlawfully
Did attempt to
chased.
confine and detain Ahmaud Arbery without legal authority on Burford using a Ford F-150 and a
Without
Chevy
legal
Silverado.
Without legal authority.
So they attempted to confine him, but he managed to get away. They basically both used the pickup trucks. So we've got Mr. Bryan, principal, actively attempting to detain Mr. Arbery. We've got Travis McMichael in his pickup truck. Circumstantial evidence that he is actively attempting to detain Mr. Arbery because
Sure.
why? Mr. Arbery turns around from the white pickup truck and runs back the other way. And this is after Greg McMichael is in the truck yelling, cut him off, cut him off, cut him off. So at this point, we've got all 3 men acting in concert to attempt to confine him there. Well, how do they do that? They go ahead and do that by aggravated assault with their pickup trucks, by placing him in reasonable apprehension of receiving serious bodily injury.
They ran
Well,
him
what does that
into a
mean? It means
ditch.
their actions, what were they doing? They're using these pickup trucks with the aggravated assault to confine and detain him. So the state has proven that they use these pickup trucks in a manner that would reasonably put someone in fear and apprehension of receiving bodily injury. What does that mean? They scared him. They scared him.
Well, I
with
don't
the
know.
aggravated
I don't know.
assaults.
I'm hoping
And that was
today,
part
but
of the false imprisonment.
I
We're
don't
going to
know.
scare you into stopping by using these pickup trucks to cut you off and run you into a ditch. They were doing it in concert with each other. I want to be real clear. The defense is attempting to conflate conspiracy, which is we pre-planned this thing, or conspiracy, which is wink and a nod. No, we're talking party to a crime. Okay. Conspiracy is a completely different charge. We are going to ask for it. But in this case, this is a party to a crime, which is intentionally doing these things to aid and abet. Mr. Bryan's in his driveway. He intentionally gets in his pickup truck to aid and abet the McMichaels, who he sees are actively trying to detain Mr. Arbery in violation of his personal liberty, falsely imprison him. He's actually in the top of his driveway looking down the white pickup truck. He can see it. Mr. Arbery's running back toward him. They can see that Mr. Bryan is now pulled out. They make a decision based on this to go around Holmes, but for their decisions on Burford, but for their attempt to falsely imprison Mr. Arbery would not be dead. The false imprisonment on Burford substantially contributed to his death because it's what made him stop running. They didn't allow him to run up Burford and onto Zellwood, which would have then led right out of the neighborhood. Because if he'd gone up Burford, gone over Zellwood, he'd eventually gotten to Satilla Drive and could have gotten away and he wouldn't be dead. So this substantially contributed. But for these actions on Burford, none of the rest of it would have happened. So what did happen? Well, he then has to run back. Mr. Bryan, of course, once again, cuts him off. He then immediately turns up Holmes to get away from Mr. Bryan in his pickup truck, which has now cut him off from his route going out Satilla Drive. But for those aggravated assaults, which were used to falsely imprison him there on Burford, he would not have been going up Holmes, which then led him to encounter the white pickup truck coming down Holmes. We have him trapped like a rat. He ends up with no place to go, and he ends up exhausted, fight or flight, turns around the corner and is shot. So all of this led up immediately to the death. And therefore, it's a question for the jury. And in this case, the standard, as the court knows, is we view all of the evidence presented at trial in the light most favorable to the verdicts and ask whether any rational trier of fact could have found that the defendant was guilty beyond a reasonable doubt. That's for the jury to decide. They're going to go ahead and look at this, and but for those actions on Burford, would he have ever been trapped like a rat between two pickup trucks on Holmes Drive? No, he wouldn't have been. So it materially and substantially contributed to his death by getting us to that point. And this is all one continuous event. This is 5 minutes of this going on. So it's not these separate little vignettes. This is continuous. They're going around. Mr. Bryan's driving him this way. They're going this way to go ahead and capture him and trap him on Holmes. And that was their intention, all because they wanted to talk to him. So we've got that. We ask that you deny the motion for directed verdict on counts 5 and counts 9. Then we've got, I believe, Mr. Hogue then did 3 and 7, which is our aggravated assault with the pickup trucks.
She's really good.
Count 7, did make an assault upon the person of Ahmaud Arbery with a Ford F-150 pickup truck and a Chevy Silverado pickup truck. Objects, devices, and instruments, when used offensively against a person, are likely to result in serious bodily injury. 2.20.21, aggravated assault with a deadly or offensive weapon. Assault another person with an offensive weapon. To prove assault, the state does not have to prove that the other person was actually injured. However, the state must prove that the defendant committed an act that placed the person in reasonable apprehension or fear of immediately receiving a violent injury. And then, of course, an offensive weapon is any object that is likely or actually does cause death or serious bodily injury if used against someone. It's not in dispute that a 5,000-pound lethal weapon like a pickup truck can cause serious bodily injury to someone. The question is, were their acts, what they did, such that it would put a reasonable person in reasonable apprehension? In other words, did what they do cause fear? Yes. Now, we don't have Mr. Arbery to go ahead and take the stand and go, yes, I was afraid. He's dead. But the jury's allowed to go ahead and look at this and go, okay, let's look at their acts. Did they commit an act that placed Mr. Arbery in reasonable apprehension or fear of immediately receiving a violent injury? Yes, both direct and circumstantially, they did, with aggravated assault with these pickup trucks. So once again, now, felony murder, we're back to our but-for situation. So but for them attempting to strike him, cut him off, run him into a ditch, impede him, run up next to him. I mean, Mr. Arbery's just running down the road and they pull up with a pickup truck right next to him and start yelling at him. Stop, stop, we want to talk to you. So at that point, just that alone, is that an action that would put somebody in fear? I mean, total strangers have pulled up next to you. You don't have a car, you're running. That's a question for the jury. Now, the aggravated assault with the pickup trucks, the state feels not a problem, proven that beyond a reasonable doubt. Did it play a substantial and necessary part in causing his death? Yes. Now, as Mr. Hogue pointed out, at the time of his death, the white pickup truck, which had already been used offensively against him, trying to falsely imprison him on Burford, and then once again, coming down Holmes Drive, goes ahead and passes Mr. Arbery. We know this, okay? Because what do we have? We've got Mr. Bryan and the video, Mr. Arbery suddenly turns around. Now, whether you can see the white pickup truck or not, he suddenly turns around and runs back down. Mr. Bryan goes up, Mr. Bryan turns around, he comes back up, and the video's there. And what do we have? That truck is parked at the end of the road. Based on their statements, Agent Dallas testified they went up Zellwood and came down Holmes. That means they passed Mr. Arbery once again with that white pickup truck. He is pinned between the two of them, the black pickup truck and the white pickup truck. And then the white pickup truck passes him when he turns around and then parks in front of him. That is the aggravated assault. But for them using those pickup trucks in that manner, he would not be dead, because he's trying to run up Holmes and the white pickup truck's coming. He runs back down. Now Mr. Bryan's at the top of Holmes and the white pickup truck's at the bottom of Holmes. He is pinned.
Yes,
Greg McMichael said he was trapped
up.
like a rat, and he knew it. That was what Greg McMichael said. So when he's trapped like a rat between these two pickup trucks, did that substantially materially, did that play a substantial and
like
necessary part in causing the death? It was absolutely necessary, because they had him between these two pickup trucks. They caused him fear. Actions put him in reasonable apprehension of receiving serious bodily injury with the pickup trucks. And at this point in time, as a party to the crime, they've stopped their pickup truck. But Mr. Bryan hasn't stopped his pickup truck. Not at all. He is coming up behind Mr. Arbery. He is revving that engine. You can hear it on the video. And as a party to the crime, they can see that pickup truck coming. Seeing that pickup truck coming didn't stop Travis McMichael from pulling up that shotgun and pointing it at Mr. Arbery. And then he tracks him around and then shoots Mr. Arbery. The fact that Mr. Bryan and the McMichaels as a party to the crime of the use of that pickup truck at that moment, it becomes felony murder for the aggravated assault with the pickup truck. The state will argue, of course, that the use of the pickup truck the entire time, but for that, he wouldn't have been where he was. But for all the actions that the McMichaels took in their white pickup truck, Mr. Arbery would not have been where he was and would not have been trying to escape this particular attack and assault. So we ask that you deny the directed verdict on counts 3 and count 7. Then we have, of course, count 4 and 8. This was the fourth one that Mr. Hogue mentioned. Pause for some water, Judge. Count 4 of the indictment, count 8 of the indictment. In violation of the personal liberty of Ahmaud Arbery, did unlawfully confine and detain Ahmaud Arbery without legal authority, to wit. Said accused did chase Ahmaud Arbery with a Ford F-150 pickup truck and a Chevy Silverado pickup truck through the public roadways of the Satilla Shores neighborhood, and did confine and detain Ahmaud Arbery on Holmes Drive using said pickup trucks. Greg McMichael's statement: he was trapped like a rat. He was trapped between the two pickup trucks. State has gone ahead and proven count 8. So how did that materially, substantially, and necessarily cause the death of Ahmaud Arbery? Because he's trapped between these two pickup trucks. He's right there in Holmes. He's running toward a man pointing a shotgun at him, and that man is relentless. He doesn't give up. He doesn't stay on the side of his pickup truck.
Yes.
So here we've got the ultimate confinement, and Judge, the ultimate confinement is death. Here he was ultimately falsely imprisoned because he was shot right there. Ultimate false imprisonment. But what they actually did,
this is sped up a little bit,
is when they put Mr. Arbery in reasonable apprehension, fear of receiving bodily injury with the pickup trucks, they had him trapped like a rat. Once again, fight or flight. All he did was flee from these people. All he did was try and get away. But according to Greg McMichael, he was trapped. Greg McMichael is standing in the back of that pickup truck, yelling at him, "Stop, goddammit, stop." He previously told him he was going to kill him. He was going to blow his effing head off. So at this point in time, if he had not been falsely imprisoned and trapped between these pickup trucks, he would not have been shot. The killing is the ultimate confinement. And I get that the defense is saying, well, he had options and he should have run this way and he could have run that way. Well,
that's the way it works.
Parked right in front of that driveway. They didn't actually go up to the stop sign at the end. They parked in that driveway. He was going around this side. There's a driveway to a house right there. He comes around the very front of it. They want to make it seem as if he's the one at fault for not continuing to run. He's the one at fault because they made him afraid. He's the one at fault because he didn't want to get, I don't know, it would be speculation, but nobody wants to get shot in the back with a shotgun. He's already been told they're going to kill him if he doesn't stop. So at this point in time, falsely imprisoning him there and keeping and confining him there substantially and necessarily caused his death. Blaming him for not continuing to run on or him utilizing his options to defend himself is not really, how do I put this? What Mr. Arbery chose to do and his intent is not relevant. The acts of the defendant that's what's relevant here. And trapping him like a rat between two pickup trucks, one of which he was actively running away from as it pursued him, forcing him towards the white pickup truck and Travis McMichael and his shotgun, that was actual false imprisonment because he never, ever got away from them on Holmes Drive. He was killed. So it substantially contributed to his death. when we look at counts, so we ask you to deny the directed verdict as to 4 and 8. When we look at counts 2 and 6, once again, 2 being felony murder based on the aggravated assault with a shotgun. Count 6 is did make an assault upon the person of Ahmaud Arbery with a firearm, a deadly weapon, to wit, a 12-gauge shotgun. To prove assault, the state does not have to prove that the other person was actually injured. However, the state must prove that the defendant attempted to cause a violent injury to the person. All right, so Judge, I hear what Mr. Hoag's saying, that pointing the shotgun at him where it's up against here is an aggravated assault, and it is. And if he had never fired at him, if he'd just done that, he'd be guilty of aggravated assault. However, as you know, our Supreme Court has recently told the state, you can't go charging different moments in time in a continuous action. They've told us that. They said you can't do it. It's all one aggravated assault. There has to be an intervening factor, meaning I think the one case that we're talking about is it was an aggravated assault on a woman, boyfriend, girlfriend, and he went ahead and slashed her face. So we got aggravated battery. Then there was an intervening time period where she got away from him. Then he went up, and I think he stabbed her in the neck. Those were 2 separate things solely because of the intervening time factor. But the courts have said, meaning our Supreme Court has held, it's all one thing. But in this particular case, the state's not contending that it's 2 separate aggravated assaults. It's one aggravated assault when he pulled the trigger and shot him. So I just want everybody to be really, really clear. The state is arguing the state must prove that the defendant attempted to cause a violent injury to the person. And he attempted to cause a violent injury to the person when he shot him point blank in the torso with that shotgun. They're all parties to the crime of this. Because Greg McMichael's already threatened to shoot him with a, stop or blow your effing head off. Mr. Bryan sees that shotgun, sees it come out, sees exactly what's going on. We might not see it on the camera, but he's driving the truck and he's driving Mr. Arbery right towards that man with the shotgun. She is phenomenal. Helping him to go ahead and commit this crime. Really good. So at this point in time, we've got the aggravated assault. Here, Travis McMichael actually pulled the trigger. Greg McMichael helped and encouraged Travis McMichael. Right? Travis McMichael grabbed his shotgun in his driveway decision at his house, chose to bring that shotgun along. Greg McMichael knew it. There's absolutely no evidence that Greg McMichael told him not to bring it along. Don't bring that shotgun. Nothing like that. Greg McMichael got into the truck with his son knowing he had that shotgun. This is circumstantial evidence. Greg McMichael's in the truck with Travis McMichael the entire time that he has this shotgun, both in the pickup truck and then when Greg McMichael gets in the back of the pickup truck, Greg McMichael's yelling at Ahmaud, stop. This
is actually not even
Greg McMichael's giving Travis McMichael directions, cut him off. I'm not. In the moment that Travis McMichael's outside, Greg McMichael can see he's got the shotgun.
Supposed to be live.
Stop, goddammit, stop is what he's saying to Mr. Arbery. That is helping, intentionally aiding, and Michael's yelling at Ahmaud, stop. Greg McMichael's giving Travis McMichael, directions, cut him off. In the moment that Travis McMichael is outside, Greg McMichael can see he's got the shotgun. Stop, goddammit, stop is what he's saying to Mr. Arbery. That is helping, intentionally aiding and abetting, knowing full well that the shotgun is being pointed at Mr. Arbery. And it's kind of encouraging. It's tacitly basically authorizing this and encouraging him because it's not telling his son to stop doing that. You don't hear put the shotgun down.
Thanks, Stephen.
You don't hear what the heck are you doing? Don't do that. You hear stop, goddammit. Travis McMichael is driving. And the one thing that's kind of important here, Judge, is that Mr. Hoag, when it came to Greg McMichael's statement, actually asked Parker Marcy a question. And it was unobjected to by Greg McMichael's counsel, but I know the court noticed it. I noticed it. It was my intention, and I know it was my son's, to arrest him or at least to get him identified. There was no objection from Travis McMichael. So at this point, what's before the court, unobjected to by Travis McMichael's counsel, is what their intentions were here.
Ooh.
And of course,
is big.
They're going to argue, well, it was to arrest him.
This is big.
Or at least get him identified. So if this is Travis McMichael's intention, it was Greg McMichael's intention. And that's what they were doing. And they were doing it at the point of a shotgun. With regard to Mr. Bryan.
All right. The reason why that's huge, that's monstrous in this trial. Why? If their intention was to just identify him, that takes off. That's not a citizen's arrest, right? He said, and the lawyer got in, their intention was to identify him. Then you don't have citizen's arrest, right? If their intention was to identify him, That means they didn't know who it was when they chased him. That they didn't know he had committed a burglary. That means all of that's out the window, right? Because their intention was to identify him. That's a bomb, right? So their intention wasn't to arrest him because they didn't know who he was. Their intention was to identify him. Damning. And that's why she said their attorney should have objected. We were shocked when he said it, but he didn't. Because their intention wasn't to arrest him. It was to identify him. And you can't stop people with shotguns in the street to identify them. Right? Wow. Hey, Nate, thank you. Watching both trials. She's a great lawyer, and I'd be exhausted listening to her talk all day. Your ears must be worn out. Respect, sir. Thank you. That's a bomb. So that's why I stopped it. That is a bomb. Taking shotguns, putting it and chasing people down to identify them. They admitted to that. Wow. To rewind that.
Mr. Bryan never called 911.
People want to hear it again. I'll let you hear it again.
At this point, it was my intention, or Marcy, a question, and it was unobjected to by Greg McMichael's counsel, but I know the court noticed it. I noticed it.
Remember, they were saying
it was my intention, and I know it was my son's.
What was your intention?
To arrest him, or at least to get him identified. There was no objection from Travis McMichael. So at this point, what's before the court, unobjected to by Travis McMichael's counsel, is what their intentions were here. And of course, they're going to argue, well, it was to arrest him or at least get him identified. So if this is Travis McMichael's intention, it was Greg McMichael's intention. And that's what they were doing. And they were doing it at the point of a shotgun. With regard to Mr. Bryan.
You can't pull out shotguns and then endanger
Bryan
people.
Never called 911.
That's bad.
Mr. Bryan continues forward
That's
recording
bad.
despite the shotgun coming out. Mr. Bryan says absolutely nothing on the recording. He doesn't go, oh my God, there's a shotgun. Oh my God, what's he doing?
Good.
He doesn't, like I said, swerve out of the way and into a ditch. He doesn't put it in reverse and back
think
up.
About
so
what
he's
all
out
that
of the line
means.
of fire.
That whole we thought he was armed from last time. They didn't know who he was. They didn't know who he was.
Slam on the brakes.
They didn't
does
know
not
who they were
protest. Does
chasing.
not yell. Doesn't honk. Doesn't do anything.
You don't know who you're chasing. How can you arrest somebody? You don't know what you're chasing.
Forward.
You don't know what you.
We get to
you
this
don't know who he was. You're just chasing somebody at random.
Pursuing,
and we were just trying to identify.
Video, Mr. Arbery had actually run away from the white
them.
truck again. Mr. Arbery runs. We see that he's going down homes towards Satilla.
No, that's what she's going to tell them in closing.
At this point, we actually see Mr. Arbery back at the blue mailbox having turned around.
No, she's going to tell them that in closing.
Back toward the white
How
pickup
could they be
truck.
wanting to arrest them?
Therefore,
if they didn't know who he was
by chasing Mr. Arbery towards
and guess what he just
the
said
white
on the stand?
F-150 pickup truck, despite Arbery's
didn't know who he
obvious
was.
attempts to get away from the white pickup truck.
Wow.
But he encounters Mr. Bryan in the Silverado, so he has to run back toward the white pickup truck. Once again, a party to the crime in making this happen.
No.
And we all know that even if your finger is not on the trigger,
was it? They didn't know he was the same guy. They
I mean, we all know the getaway driver who doesn't go into the convenience store is just as guilty as the guy who goes into the convenience store and pulls the trigger because he's there to help make it happen. Help make it happen. And here we have Travis McMichael actually pulling the trigger, Greg McMichael helping to make it happen, and William Bryan helping to make this happen. Because without their help and assistance, without their Greg McMichael, especially his encouragement, Travis McMichael would not necessarily have been able to complete this had not Mr. Bryan driven Mr. Arbery toward the parked white pickup truck. If Mr. Bryan had actually kept going and up around Zellwood or had left, Mr. Arbery would have been able to keep running up Holmes and maybe get to Zellwood and Satilla. Thus, Mr. Bryan confining him there contributed substantially and materially to the felony murder and the aggravated assault with a deadly weapon. So we ask that you go ahead and also deny the directed verdict.
We were shocked, and even the court was shocked.
2 and 6 of the indictment.
Told them that he may be armed. They told them that we cleared up earlier. For the police were racial profiler. What was the evidence that he was armed? I'm not aware of it. Just
they found a word from the McMichael defendants on that.
They were.
Yes, just very briefly, Your Honor.
The McMichaels called
Can you hear me
911 and
from
told
here?
the police that they were armed.
Citing
So when police
the
got there, the police thought they were
language
actually
of State
armed
v.
based on what the
Jackson,
McMichaels had told them earlier.
287 Georgia 646 2010.
But that's what I want
Georgia
to make it
Supreme
very
Court
clear.
Case.
The McMichaels
Justice
told the
Namias.
police that they were armed. So
We
when the
have
police
also
got
said
there,
that proximate cause
then the police
is
used
standard
their
for
reference that he was
homicide
armed
cases
to believe that he was
general.
armed. So
And
it
then
was actually the
cites
McMichaels who made
cases. And,
the thing that they were armed. It wasn't the police.
is
The police
quoted
were going
from
off of what
Wilson
they
v.
said.
State. We set out the following tests for determining causation in homicide cases. Where one inflicts an
I
unlawful
don't know.
injury,
I don't
such
know.
injury is to be accounted as the efficient proximate cause of death whenever it shall be made to appear either that.
Decent arguments,
Three
but
subparts.
will the jury buy it?
One,
I'm not too sure.
the injury itself
You're trying to arrest somebody
constituted the sole
for a felony,
proximate
but you don't know who the
cause of
person
death.
is.
Or two,
Yeah, I'm
the
in
injury
NYC.
directly and materially contributed
I was a
to the
Marino fan.
happenings
I was a
of
Marino
a
fan.
subsequent accruing immediate cause of the death. Or three, the injury materially accelerated the death, although proximately occasioned by a pre-existing cause. That one doesn't apply here. So the proximate cause issue in counts 2, 3, 4, and 5 is at the heart of our motion. And I think the state's failed to make that connection between the underlying felonies.
Time for you guys to vote. We're going to see
that are
who
named
got
in
the best of this
counts
argument.
6, 7, 8, and 9, and the accruing death based on this test from this case. And of course, that's a completely different problem than the malice murder, and I won't say anything more about that. So that's our response to the state's, our reply to the state's response.
I'm sorry, may I distinguish that case, having just heard it, not knowing it in advance? That case was a co-defendant felony murder case, meaning a whole bunch of people went in to commit a crime, and the victim fought back, and it ended up with one of the co-defendants murdered. So they're talking about proximate cause for the armed robbers, one armed robber being responsible for the death of his co-armed robber. That's what that case is about, not this sort of situation.
I will just add that next paragraph says, consistent with this general rule.
Very good point,
Which I
Oliver.
just read. We have held in many cases and for many decades that the proximate causation is the standard for murder cases prosecuted under the murder statute codified at OCGA 1651. The particular facts of this case are immaterial. It's the rule that I'm talking about.
Mr. Goff, on behalf of Mr. Bryan, any directed verdict?
Oh, this guy is insane. I think Oliver's point is a very good point. Now, I usually agree with you, but in this case, I think the identification refers to
Good morning, Your Honor.
unclear about
No, first thing
what it was.
I'll do is I'll
Agreed. You
formally adopt
This is a very, very
the
good
very
rebuttal.
cogent arguments
But
made by co-counsel
rather than
in this
previously
case.
attempted identification methods, yes.
And without tracking through those,
Very
but
good
for Beth Brigmo giving birth to Roddy Bryan, God rest her soul, many years ago, but for that, Roddy Bryan wouldn't have been out there that day in his pickup truck. When we use this but-for causation, that there's a lot of baggage that comes along with that. And
Did it just say but
with
for
all
his
due
mom
respect
giving
to Ms.
her
Donkowski, it feels
birth
like
to
they
her?
are stretching that term beyond recognition. The legal standard is proximate cause.
It's the but-for test.
And
It's literally called the but-for
we'll come
test.
back to that in a moment. But when you look at it as proximate cause and not simply reducing it to two words, but for,
Yeah,
I think
that's
the
what
court
it's called.
understands why the defendants are here making these motions. Your Honor, with respect to count one malice murder, I'm really at a loss here to understand, but it was the state that decided to present what we sometimes call a kitchen sink indictment to the grand jury, where every defendant is charged in every possible way with every possible crime in this case. That was a decision the state made, and I certainly appreciate the challenge to the court in trying to assess these issues. As I look at the malice murder charge, there is no contention that Roddy Bryan shot anybody. There's no contention that Roddy Bryan tried to shoot anybody. There's no contention here that Mr. Bryan is acting as a principal. This is, if I misunderstood Ms. Dunkowski, I'm sure she'll correct me. The entire theory here is aiding and abetting, third section of that statute. And
Yes.
where is
That
it
means Arbery
that Mr.
gets
Bryan
self-defense
is
and they do not.
intentionally
They're wrong
aiding
about the
and
burglary.
abetting the shooting? Because
They're
he's
wrong
not.
about the burglary.
Now,
Ahmaud Arbery is
maybe some
think about this.
decision came out of
Ahmaud
the Supreme
Arbery
Court
is
last week or last month that I'm
is Kyle
unaware of.
Rittenhouse.
But when I went back through Kurtz last night, or it used to be called Kurtz,
If the burglary is no good, Ahmaud Arbery
section on
is
parties
Kyle
to the
Rittenhouse
crime. I know the
without
court
the gun,
knows the treatise that I'm talking
being
about.
chased
You know, they list
by
like
the
30
McMichaels
different ways
who
that
have
you
the
can
guns.
be a party to a crime, that you can be aiding and abetting in a murder case. But none of those are like the case before this court, which is why, although Ms. Dunkowski has cited this court well over 100 cases in oral argument, probably thousands of cases, and all the pleadings that have been filed and motions that have, and responses going back and forth, Ms. Dunkowski cannot cite to you a single Georgia case that is remotely comparable to the one that we have before the court. This isn't the case where Mr. Bryan's driving down the street in his pickup truck and Travis McMichael is standing in the back of it shooting at Mr. Arbery. This isn't that case. There is no case, and she can cite no case remotely close to this one. The closest cases that I've been able to find, and of course they're referenced in there, in what I call the distraction aiding and abetting cases, in which one person intentionally distracts another person while someone else behind them either takes a knife and stabs them with it or shoots them. I call them distraction cases, where you're aiding and abetting by distracting. There is no evidence and no suggestion here that Mr. Bryan's conduct has somehow distracted Mr. Arbery. He's well aware of the pickup truck in front of him from the video. He's well aware from the video that they are both armed. So, and Mr. Arbery is not shot with his back turned. That might pose a different and a closer question for the court. But in this case, unless Ms. Dunkowski can cite some Georgia case suggesting this, which I still don't understand, theory of aiding and abetting the shooting of Mr. Arbery, there simply is no malice murder case here. And, you know, co-counsel points out some pretty good cases on what the mens rea is required here. Where is any of that for Mr. Bryan? There's no malignant heart in this case. There's nothing from which that could be presumed. And, you know, that takes us back to the whole concept of a citizen arrest. If I understand the state's theory here, the state contends that the McMichaels, and I believe they're contending that Mr. Bryan was assisting them or aiding them in attempting to make a citizen's arrest, which in the opinion of the state was not authorized under Georgia law.
Boom.
And that may be true, Your Honor. But the fact that Mr. Bryan aided and abetted a citizen arrest, if he did that, doesn't establish malice in this case. It doesn't establish an intent to aid and abet an intent for a shooting. You know, and Your Honor, I would urge the court to ponder the larger implications of the legal ruling that the state is requesting here.
This is
because
not making any
in
sense.
this one case,
That's not making any sense.
It might serve the interests of the state. But in the larger question, if 10 police officers respond to a call, 10 police officers pull their cars up around a scene, and they're there, maybe they're still moving, Your Honor. And inexplicably, a police officer discharges his weapon and shoots the person that they're after in the head. Maybe they had probable cause, maybe they didn't. But are we going to try every police officer who's present at the scene of an attempted arrest for malice murder because somehow in aiding and abetting an attempt at an arrest, lawful or unlawful, that translates into aiding and abetting the shooting that follows? That can't be the law, Your Honor. And we shouldn't be creating special rules of law. There are already enough of those. We shouldn't be creating any more special rules of law for one case, because we know the reality is that these things have unintended consequences and they take on a life of their own. We don't need to start down this theory that anybody who's attempting to arrest someone, which after the last legislative session is pretty much limited
So
to
he's
police
saying
officers.
they're like police
that anytime
officers?
police officers are attempting to
But
arrest
police
somebody,
officers have special
particularly if they're
powers, though.
attempting to
That's
do so
special authority.
unlawfully,
I don't understand what this guy's
that
talking
they're
about.
aiding and abetting the arrest, lawful or unlawful, is aiding and abetting a shooting or other unlawful use of force that follows.
Oh, I don't know. I
There
don't
is
know.
no
the case.
malice murder case as to Mr. Bryan.
Oh, thanks.
There is
I'll
no
check it out though,
authority
but
for
I
this
don't know.
case.
All right,
The state wants
so
to
he's
talk about but for. I want to talk about intervening factors.
all right, I'm just going to stop it right here because in his hypothetical, what if one officer is doing something crazy and you got 4 officers who are assisting him in that crazy thing? Well, I'll bring up one case where that officer was convicted of murder and the other officers are on trial right now for the conspiracy or assisting him in that murder. That's the George Floyd trial, right? Chauvin was convicted, but the other 4 cops who assisted him in that unlawful arrest or that incident are now being charged. So what he's saying is that if those officers actively helped someone do that, that's George Floyd. So he's giving this. I don't know if he's giving his client up or something, but that's exactly what happened with George Floyd. And those officers were charged and are being prosecuted. I don't know. I don't understand his argument.
And before I do that,
But
Your
he's
Honor,
right.
I would
You can
maybe
be
it's just
charged,
me.
even if you're an officer.
Maybe I'm just not
Officers
smart
have been
enough to keep
charged.
up this
Matter of fact, that happened in Atlanta.
The way
There
Ms.
was a case in
Dunkowski
Atlanta
is
where that
presenting this
happened. One
malice
officer
murder
pointed
argument
a
to
gun
the
at
court
one guy.
is in essence collapsing malice
the DA
murder
charged
into
him.
felony murder.
I don't
What
think he
distinction is left here between malice murder and felony murder when Ms. Dunkowski makes these arguments? Because it's winding up being the same thing. Well, he intended to shoot, therefore he intended to kill, or he intended to falsely imprison. He must intend to
They were
shoot.
charged with aid.
How do we distinguish at the end of the day with the arguments made by the state between malice murder and felony murder?
But Chauvin's arrest wasn't
This is a
unlawful
case,
arrest. It was actually a
and
good
this
arrest.
feeds into the severance
It was just
issue.
excessive
With all
force.
due respect to Ms. Dunkowski, I would humbly suggest to the court that if Ms. Dunkowski continues to proceed along this line with malice murder, and we go into the defense case here, we are going to have
On the break, I'm going to go into the Brady
at some
violations.
point antagonistic defenses that cannot be overlooked. The state, as I understand it, has not submitted a charge on manslaughter. My understanding that learned co-counsel from the McMichael defendants has not submitted a jury charge on manslaughter. And part of that, I think, well, there's different strategic reasons why people do things, but my point to Your Honor is, in terms of proximate cause, do we not have not one, but 2 intervening factors here? Factors that are not reasonably foreseeable to Roddy Bryan. Maybe logically foreseeable and something that's conceptually possible, but not reasonably foreseeable in the sense that the law would imply. You have in the video, and unless I missed it, this part of the video, the state contends is undisputed, uncontradicted.
I'm trying to understand his argument.
In the video, at the
defense
last
attorneys
minute,
have made some really good
you
arguments.
see
But this guy's
Mr. Arbery, instead of turning right towards the exit of Satilla Shores, he turns to the left. Now, it's not for me to judge or question why Mr. Arbery does the things he does. But when he turns left instead of right, regardless of his justifications or his reasons for doing so, that is an intervening cause, an intervening circumstance, I submit, under Georgia law. And at that point, it's not foreseeable to Mr. Bryan. It's not foreseeable that just like on the street with the police officers, suicide by cop is not reasonably foreseeable, nor is suicide by citizen's arrest. When Mr. Arbery turns towards Mr. McMichael, that is an intervening circumstance that breaks any causative chain here with respect to the shooting and death itself. Likewise, and I'm certainly not taking sides in this.
Arbery,
for the jury and the court to determine,
committed suicide by citizen's arrest.
But at the same time,
that's his
argument. Second intervening factor. The first intervening factor is Mr. Arbery pivoting to the left instead of heading for the exit. The second intervening factor is Travis McMichael discharging his weapon. And I'm not questioning why Mr. Arbery is doing what he's doing. I'm not questioning why Travis McMichael is doing what he's doing. But what I'm saying is you have a second intervening factor, which is the choice of Travis McMichael to discharge his weapon. It doesn't really matter for purposes of evaluating count one malice murder, if the court can see that whoever's in the right here, whoever's in the wrong, whichever party is using excessive force, maybe both parties are using excessive force.
Wow,
Maybe
he
there's
didn't
some
bring up
kind of
excessive
mutual
force.
combat theory to be had out there. But from
Mutual
Mr.
combat
Bryan's
theory.
perspective, in terms of proximate cause, in terms of what's reasonably foreseeable to him, none of these things are reasonably foreseeable. And I think the court understands the consequences if the court were to go down any other road. And if we're going to persist with this issue, we're going to wind up in a severance posture. It may be premature. We haven't heard whether any of the other defendants have testified yet. But I would submit the easiest way to resolve the severance issue is to grant the motion for directed verdict for Mr. Bryan as to malice murder. Moving on to count 2 felony murder, which is tied to count 6 aggravated assault to a shotgun.
So we have the old,
again, the arguments
committed suicide
come down
by
very much
citizen's
the
arrest.
same way, because the state's position on malice murder is essentially, although not in so many words, collapsing into felony murder. Where is the intent on the part of Mr. Bryan to facilitate an aggravated assault with a shotgun? Again, it's one thing to say
It's
the
working
state
in
contends that's
concert,
what the
right?
evidence
They're
shows,
saying they're working in concert.
that Mr. Bryan is attempting to assist in a citizen's arrest, aiding and abetting a citizen's arrest. But there's nothing reasonably foreseeable about
That's true, but they said,
killing
but they admitted
someone
they didn't know who he was.
in a citizen arrest, just as on
He
the
fit the
street,
description, but they
there's
didn't know who he
nothing
was.
reasonably foreseeable police
So
officer
I agree with
when a
that.
fellow officer, without cause,
You don't have to know who they
discharges
are,
a weapon,
but
in these days, maybe
if
even a
they-
taser, and
if
kills
their
somebody.
thing is to stop them to identify him,
Again,
and he
there
wasn't
is
the
no
person.
proximate cause, and there is no mens rea. There is
Listen,
no
let's say they
aiding and
stopped them,
abetting the shooting.
and
Now,
and they were wrong.
Ms. Dunikowski wants to make a big deal of the fact that the gun is visible.
All right, so this guy's making bad arguments, but let's say this is true. You can recognize someone with being able to. Well, I'm assuming it's without being able to identify them. True, right? You can. It's that whole. I know who that person is, but I don't know their name. Right? That's essentially what you're saying. I'm assuming that's true, but the issue I think you have to resolve is they saw someone, right? And the only thing they knew at the time, it was a black person running. They didn't get to see height, weight, or anything. They just saw a black person running, and who had a white shirt on. So they were going to see who the hell that black person was. So even if I'm assuming that's true, the whole premise of the chase, the whole premise of why they got him, right, was to try to figure out who the hell is this guy, right? Who the hell was that guy? Not even was this the same guy? And if you catch him, let's say you catch up to him, and you stop and you say, okay, we got you, and it happened to be the wrong guy, right? And you're like, oh shit. You know, you've just committed all these particular felonies. And that's what the state is saying. But, you know, if you caught him, it's the wrong guy. They didn't know. They didn't know. Now, if they have evidence to show that they knew, like we knew exactly who this guy was, then we got a different story. But it doesn't seem like they know. They guessed.
That Mr. Bryan's truck is still moving,
And you
although
can't-
obviously at a slow rate of speed.
You can't pull out your weapons.
And therefore, because he
and
doesn't
stop
run
people to
in a
identify them.
ditch,
That's just not.
or he doesn't
That's not the way it
back
works.
up, that he somehow is now
Unless
joining
you
in the
don't have the
shooting.
rights
But
to
again,
pull out your firearm to identify.
I think
people. that's just.
I
not the
understand
way
the
it
state's
works.
position is pretty clear, almost uncontradicted, that this is a purported attempted citizen arrest. Again, in the context of a citizen arrest, is the fact that Mr. Bryan is maneuvering his truck, and positioning his cell phone to follow Mr. Arbery and document what Mr. Arbery is doing. How does that circumstance, whether he's traveling at 2 miles an hour, 4 miles an hour, or 6, how does that establish his aiding and abetting the shooting itself? Because Mr. Bryan only has knowledge of the existence of the weapon, as we see on the video, at the very last moment. And still, at that time, from Mr. Bryan's perspective, even if he's attempting to aid and abet a citizen arrest, that's not the same thing as aiding and abetting a murder. I mean, would it be it's the same thing, Your Honor, whether Travis McMichael is shooting him or not, or whether he's pulling out a club and beating him on the side of the road, or the billy club, like a police officer would do. Again, how is Mr. Bryan's assisting, if that's what it is, in a citizen arrest, showing that he's attempting to aid and abet the shooting, aiding and abet an unlawful, excessive use of force in the making of an arrest? That's just not there. That's just not Georgia law. And again, the state says the jury should consider the fact that they had their guns drawn. Okay, well, how is Mr. Bryan again to know that they have any intent in drawing a weapon, whether it's in the down position, the up position? I'm not a use of force expert, but whatever position. Again, how is that telling Mr. Bryan that they intend to use excessive force, that they intend to kill him, that they're not trying? Maybe that.
All right. I got to stop this here. This argument is viciously bad, and I'll explain to you why. What he's essentially saying is his client didn't know that they were going to kill him, right? They didn't know he was going to use it, and that he would need that knowledge to be held liable for, under the theory of felony murder. So you know what that is? That's like us going to rob a bank, right? And we all got guns. I know they got guns, and we're all going to rob the bank. And I'm the last guy in the bank. And we're in the bank and we're robbing the bank. And one of my compadres kills someone. And then we all get caught, and we're on trial for bank robbery and for that murder. And my defense is I didn't know he was going to shoot someone. So I should not be held responsible because that's the intervening cause. I had no idea he was going to shoot someone. But generally, the law would still hold you liable for that because the situation, you knew they had guns, you knew they were doing this, and since someone died, that makes you liable for the situation, even though you didn't assume, you didn't plan on killing someone. The fact that someone killed, that's what it gets you. So that's the argument he's trying to make, which I don't, maybe Georgia law may be different, but that his argument is not making sense, right? His argument is not making sense. And he's given up the fact that he's saying it doesn't matter about the legality of the citizen's arrest, whether it's legal, whether it's not legal. He's saying that that's his argument is that. Now, if he's saying his motion to dismiss has to be predicated on the fact that it's a false, because the prosecution is saying the citizen's arrest was false. So his argument has to assume that this citizen's arrest is false because we understand where we're at in the process. This is essentially a motion to dismiss. So they're saying we're giving the state everything the state is saying is correct. So if everything the state's saying is correct, then this citizen's arrest is false. And even if the citizen's arrest is false, which is an illegal citizen's arrest, which is false imprisonment, I still win. So if someone in the chat says, well, robbery, this was a lawful, bank robbery is illegal. Well, that's under the impression that they're arguing. They're arguing under the standard where, yes, the citizen's arrest was illegal, but even if it was, we still win. So that's why I'm saying this argument just doesn't logically follow for me, but I may be wrong. We'll hear him out.
That's the state's theory, that they weren't really trying to make an unlawful arrest. They were just looking for an excuse to kill him, or they were just waiting for the opportunity, notwithstanding the fact that they've had lots of opportunities to shoot this gentleman over 5 minutes. He's clearly, in terms of proximate cause, when you look at the video, you see Mr. Arbery.
Well, you don't have to even know that they were committing
He's well
a felony.
within shotgun range. He's also well within range of Drake McMichael's handgun.
He knew that they were going
at the time that Mr. Bryan is pulling up. From Mr. Bryan's perspective,
really in prison, Arbery,
he didn't have any reason to think they were trying or intending.
I know they're going to the bank. I know
they had ample opportunity to do that long before he got there.
He has to give up the fact that it was legal. He has to give up the fact that it was illegal. That's the standard that we're under
based
now.
on the underlying count 6 aggravated assault.
He has to give that up. And he even gave it up early. He said it doesn't matter if it's citizen's arrest or not.
Count 3, felony murder, aggravated assault with a pickup truck. Your Honor, although the statute defines the grounds for a directed verdict, I believe Ms. Dunikowski has acknowledged that it's not that simple, that the standard essentially goes back to Jackson v. Virginia. It's not just whether there's quote unquote any evidence to submit something to a jury. There has to be sufficient evidence from which a rational juror could find guilt beyond a reasonable doubt. In the special demur, it's troubling to me that the state comes in here when 3 police officers, Your Honor, 3 seasoned police officers, two well-seasoned, one we can argue about, all interview Mr. Bryan, and that's the basis of this count.
Thank you, Mary.
Is Mr. Bryan's statements himself. There's no other evidence other than that in this case.
I assume so too.
And all three of these officers interviewed Mr.
I do want to say this. I agree with this. They had an impression who he was, but they no. Either way, I don't think it's. If they may have I agree. I think Mary's spot on. They had an impression of who he was, but they didn't really know.
Mr. Bryan at length.
And got caught
all
up
three
there.
summarized those interviews.
I could have said
none
it
of
myself.
them refer to Mr. Bryan's conduct as an aggravated assault. None of them do that because it's not there. The jury, Your Honor, is required to get to the truth of the matter. It's not just the words that Mr. Bryan uses, which anybody's words can be twisted out of context. It's the context in which they're given. It's the meaning that's meant to be conveyed. And it's clear from the testimony of the state's own witnesses that that meaning is not there. There is no aggravated assault with Mr. Bryan. And I'm jumping back and forth here, I guess. Make sure where I am.
I'm not getting this. I'm not getting it.
The evidence is in terms of the speed, for example, that while the state refers to Mr. Bryan as chasing, that the evidence is on the video is at 2 miles an hour.
So just
Your Honor,
chasing
with
people at
respect to
2 miles
count
an
8,
hour
the false
isn't really
imprisonment,
chasing.
The indictment alleges, and the state is stuck with the language in the indictment, that that the confinement and detainment occurs on Holmes Drive.
Okay.
But the evidence that the state is relying on is coming from Burford, and he can't be convicted at this point of that. And how the court would charge the jury, I have no idea.
On a different street. He's on a different street. The street is wrong in the indictment, he says. So that they should dismiss the murder charge.
Your Honor, on count 8, the false imprisonment. I talked earlier about the breaking containment. There is some Georgia case law out there, and
breaking containment.
For example, I guess this is the best analogy I can come up with here.
So if you're being imprisoned, here it is. He's bringing up bank robbery.
When an individual committing a bank robbery pulls out a gun and tells everybody to get down on the ground.
Okay.
Under Georgia law, that is a false imprisonment.
Yes.
Because they get on the ground.
No.
But this case isn't the case where they get on the ground.
It's a false imprisonment
Mr.
because he said it.
Never submits to being arrested.
You don't have to submit to be falsely imprisoned.
And in this case, this is the equivalent. What the state is pursuing here is the equivalent to someone in a store saying, everybody get down on the ground, and the person just continuing to run right out the door.
Yeah. They attempted to falsely imprison him.
And that is not a false imprisonment under Georgia law. And again, if Ms. Dunikoski has a case citation for this court to any Georgia case that is remotely factually close to this one, I'm sure she'll present it, but I can't find it. Your Honor, attempted false imprisonment, that's count 9. We contend that the evidence is simply insufficient to submit that matter to the jury. Moreover, we think the evidence that was presented during the state's case in chief shows affirmatively abandonment. That Mr. Bryan has abandoned this chase, as they call it, and the video itself, I think, demonstrates that at the time of the shooting, Mr. Bryan is simply a witness to the shooting itself.
All right, so the
under
problem
those circumstances, we believe that he is entitled.
So the problem with that argument, where the evidence shows that he abandoned, that's a jury question, right? That's a factual matter. The jury has to come to the conclusion that he abandoned. The state rejects that. The state says he didn't abandon; he was still doing it. So let's understand, we're at a motion to dismiss, right? So you have to accept the state's evidence as true. The state says he was chasing him. So now he's challenging the state's evidence. So his argument is not appropriate because we're saying everything the state's saying is true. We still win. But he's not saying that. He's saying, I'm challenging what the state's saying. He abandoned the chase. So this argument is not appropriate for where we're at in the trial. That's good for the jury, but that's not good for this particular moment in the trial because we're assuming what the state is saying is true in this moment.
To have an acquittal as to count 9 and all the other counts in this indictment. We would ask that a directed verdict be granted on all counts and that Mr. Bryan be released forthwith.
Before the state responds, did we break briefly for restroom?
Yeah, it's going to take a 10-minute recess. Let's go ahead and take 10 minutes. We'll reconvene at 10 of. Thank you.
All right, 10-minute recess. Rittenhouse hasn't come on yet. So I want to go over the big development last night. I got the motion papers. So I'm going to ask people, do they want to go over the motion papers for the defense while they're on break? Let me go live here and then state this here. All right, so let's go over the Rittenhouse motion to dismiss that was dropped last night by the defense. I think I read it. It is a well written motion to dismiss. It is a fantastic motion to dismiss, to be honest with you. So we'll go over it right now. It was sent to me by a fan. I got to send him an email. It was to thank him for it. But here it is. So this is the motion to dismiss that you're seeing on the screen. That's in the Rittenhouse case. So we are now at the Rittenhouse case while they are at break, and I'm showing you the motion to dismiss that was filed with prejudice. So the defense is asking the judge to dismiss the case with prejudice for this. So we have a couple of here are the grounds for the motions to dismiss. I'm going to just skip through some of this. On August 21st, the state filed a second other acts motion seeking to admit evidence of a video showing the defendant sitting on a vehicle. The other acts motion was heard on September 21st. The state did not file a motion for reconsideration or any other motions. On November 8th, Kyle Rittenhouse chose to exercise his right to testify in his defense. Prior to the testimony, the court conducted a colloquy with Mr. Rittenhouse regarding his rights, letting him know that, hey, there's a real danger here in doing this. Further, the court inquired about other areas of possible inquiry, as they're supposed to do. The court indicated it was thinking about it and had not heard anything that would change its mind. So, in other words, earlier, what they're saying is earlier, there was a motion about some evidence they wanted to bring in. The court said, I'm not going to let it in, but I'll think about it. And at this moment, they were like kind of waiting to see what the court would think. So the court said, I'll think about it, but nothing's changed my mind. So I don't know if I'm going to bring it or not. The court stated, unless there's something else, then we'll move on. So the state did not indicate they had anything else to say about the ruling. So at that point in time, the state wasn't sure if it could come in or not, but the court had kind of made it seem, if you got something else, bring it, we'll let it in. But if not, then we're gonna not let it in at this one. So now we're good to the thing. On cross-examination, the state asked the defendant, since August 25th, 2020, this is the first time you've told your story. Now, the court sustained the objection, and then shortly after that, now the reason why the court sustained the objection, because that's a violation of his Fifth Amendment privilege. After you've gotten the right to remain silent, after you said, I have the right to, after you've been arrested, you have the right to remain silent. And the prosecutor can't say, well, since you remain silent, we're going to use that against you, right? The fact that you didn't tell anybody, right? Because you have the right to remain silent. So by saying what he just said, with this motion quotes, that this is the first time you told your story since August 25th, that's post-arrest silence. Therefore, he violated his constitutional right, his Fifth Amendment right. There was objection. Shortly thereafter, the prosecution stated to the defendant, so it was said, it was objected to, that he sat through the trial, had an opportunity to watch all the videos played in court, and he had the opportunity to listen to testimony of all 30 witnesses and testified. And after all that, now you're telling your side of the story. Again, a violation of the Fifth Amendment, because you can't inquire about why the defendant didn't talk before, because he has a legal right to remain silent, a constitutional right. So they did it twice. The question required the court to excuse the jury and remand the state about the defendant's constitutional right to post-arrest silence, your Fifth Amendment privilege. The court indicated that the prosecution was either over the line or right up on the line, and the court didn't want any other problems. Number 9, after being warned about post-arrest silence, the state violated the court's order regarding the admission of other acts of evidence. This is the thing before that the court said we're not too sure we're going to let in. That by asking the defendant, you previously indicated that you wish you had your AR-15 to protect some property. The court then admonished the state's violation of the previous order. Like, hold on, we told you couldn't bring that in because that's propensity evidence, and that's not allowed. So and that was that whole thing where we saw the judge yelling at him. The defendant moved for a mistrial with prejudice. The court indicated that would take it under advisement. After a lengthy comment, the prosecutor then said, I thought my good faith belief, I thought my good faith belief, you had left the door open a little bit, but a little bit. Now we had something new and I was going to probe it. The court responded, I don't believe you. So if it's not good faith, it's bad faith. On February 5th, 2021, the fifth day of the trial, the prosecution turned over the defense footage of the drone footage, which was captured on August 25th. The problem is the prosecution gave the defense a compressed version of the video. What that means is the video provided to the defense was not clear as to the video kept by the state. So the state gave the defense the video, but it was a fuzzy video when they had the high definition version of it. So they gave them a cheaper video. This file size of the defense video was 3.6 megabytes, and the state's video was 11.2 megabytes. Further, the dimensions of the video were smaller, 480 by 212. So they're saying they had an HD version so they could see everything clearly. They gave us this one which you couldn't see everything clearly. That was obviously compressed, so we couldn't see it. The video which was in the state's possession wasn't provided to the defense until after the trial concluded. So that's a Brady violation, right? If this evidence showed any indication that the defendant may be maybe not guilty, then you got to turn it over. So they're saying that they didn't turn over this vital piece of evidence, but they kept it for themselves. During the jury instruction conference, the defense played their version of the video for the court to review. The state indicated their version was much clearer and had their tech person come onto court to have the court review the clearer video. The video is the same. The resolution of the video, however, was not. The state did not provide their quality video to the defense until Saturday, November 13th, and only did so upon specific requests by attorney Wisco, 2 days before closing arguments and after the evidence has been closed. So this is damning. I'm just, I know I'm reading it. I'm sorry. Let me go back to the chat so I can see what you guys are saying. This is really damning stuff. This is really, really damning stuff. So this is the prosecution essentially sandbagging the defense by having better quality video, giving them a bullshit copy of the video. Then after all the evidence is closed and them arguing over it, saying, hey, we got a better version of the video. And the defense is like, well, hold on, we couldn't see anything with that video. Why didn't you give it to us earlier so we can actually go through it? But they sandbagged them with giving them the video after the evidence is closed, so they can't put it back in. So the defense is like, that's, it's horrible. We and then when they were looking to see about the video, they said, oh no, we got a better version than they got because we gave them the fucked up shit. This is crazy. This is crazy. This is a well-drafted motion to dismiss. I'm sorry if I'm missing any. Let me just see if I pick up any super chats. No, so everybody's everywhere. We're all good. We're all caught up on super chats. So yeah, so this is insane. 13. Ordinarily, a mistrial will be granted upon the motion by the defendant. It's presumed that the defendant has made the election to abandon the valuable right of being tried before a single tribunal. However, a different rule applies when the mistrial motion is induced by prosecutorial overreach. In this case, it is asserted on the constitutional prohibition against double jeopardy, which would bar retrial. So they're saying if you find that the prosecutor overreached and essentially forced a mistrial, then double jeopardy applies and Kyle is free, right? Kyle cannot be retried. It's like it's over. It's like it never happened. And he can't be retried. On the following elements are required to bar retrial of the defendant who moved for and obtained a mistrial due to prosecutorial overreach, or essentially prosecutorial misconduct. 1, the prosecutor must be intentional in the sense a culpable state of mind and the nature and awareness that his activity would be too prejudicial to the defendant. So the prosecutor has to know what they're doing, and you got to kind of show they know that they're doing, and they know that it's prejudicial. 2, that the prosecutor's actions was designed to either create another change, designed either to create another change to convict, that is, provoke a mistrial in order to get another kick at the cat. I like that, kick at the cat, because the first trial was going badly, or prejudice the defendant's right to successfully complete the trial, complete the criminal confrontation at his first trial. So either they did it because they were trying to provoke a mistrial to get to, so they can do it again because the trial was going badly, or they're trying to prejudice the defendant's right so they can get a conviction now. Let me go back to, because I know I'm reading this and I know it's everything's coming in hot, so I'm sorry, but yeah, this is, I'm kind of shocked even reading through it again. I've read this news before, but I'm kind of, it's like shocking to hear this. Sorry. Do you think the prosecutor could be disbarred for shit? Oh yeah. Oh, this is not good. This is not good stuff. This is not good stuff, especially when the judge already says he doesn't believe you. But there's more. We're going to get through this. The prosecutor's conduct is clearly intentional. So they're going through the elements. So the first one they're going to show is intentional. Initially, he asked the defendant about the post-arrest silence. Oh, let me stop this. All right, Arbery's back, but we're going to stop this because we're going to finish going through this. So Arbery's back. We're going to finish. The prosecutor's conduct is clearly intentional. He asked the defendant about a post-arrest silence, and that objection was sustained. Then he did it again. So after one time, we sustained it, and the intention is because he did it again. That shows the intention, right? Further, prior to the defendant taking the stand, the court not only foreclosed the introduction of other acts. The court said, unless there's something else on that, and the state said nothing. Shortly thereafter, violating the court's ruling, that behavior by the state was intentional. He knew it would be prejudicial to the defendant. He had previously attempted to get the evidence admitted as a bad act. As it relates to the compressed drone footage, the prosecution should be required to explain to the court why it did not copy the footage for the defendant in the same quality as their copy. The video footage has been at the center of the case, right? This was their provocation offense. The idea that the state would provide a lesser quality footage and then use that footage as the linchpin for their case, and it is the very reason that they requested and were granted the provocation instruction by the court. So the video, they gave them a lower quality video, had the better quality video, and then asked for the provocation instruction based on their high quality video. The failure to produce the same quality footage in this particular case is intentional and clearly prejudicial to the defendant. I agree with that. There's no way you can get around that. The record has bad faith on the part of the prosecutor. So now they got to show the prosecutor had bad faith. We know that because he attempted to inform the court of his good faith basis for asking the question regarding the inadmissible evidence, and was told, I don't believe you. So the court did say that. The court said, I don't believe you. If it had been a good faith basis for seeking the admission of previously excluded evidence, then it is bad faith. So it is not good faith. If it is not a good faith basis for seeking admission for previously excluded evidence, then it is bad faith. The court has made the statement that it does not believe the prosecutor's statement. It is reasonable to conclude that the court believes bad faith was involved. So we can go on with this, but that is the flavor of this motion to dismiss. So, this motion to dismiss is no joke. This motion to dismiss is no freaking joke. The conduct of the prosecutor, whose arguments are supported by law in the case of Arbery, is pretty stark compared to the prosecutorial misconduct in the Rittenhouse case. She is much more convincing. Damn right. This is prosecutorial misconduct. That's what this is. And I think if I was a judge, I'd be granting this all day. So yeah, this is wow. Even if you think you got a good case, you don't do something like this. So, let me know in the chat. What do you think? Do you think the defense has made out a very good case for prosecutorial misconduct? That seems wow. And then you have a little Brady violation in here too, because they're going to say that evidence was paramount. If you had this evidence, he didn't turn it over. You might have a little Brady violation in there too. So that's even worse. And that gets you disbarred. Brady violations get you disbarred if you're a prosecutor. Shit. I'm honestly feeling a little sorry for poor Binger. he's like, what the hell's wrong with you? Like, these are things you're supposed to know you're not supposed to do. This is fucking ridiculous. Fuck. Yeah, this is shady shit. But I don't know why give up your career, right? Why do this? Why give up your career? Why? It just doesn't make sense. It just doesn't make fucking sense. Nate, the lawyer, I do think the judge in the Rittenhouse case is very worried about now being portrayed in the media. Maybe, but what's right is right, though. If they're essentially hiding evidence from the fucking guy, right? They violate. You got two constitutional right violations. You got trying to get evidence in unjustly, and then you got hiding, and then you literally got hiding evidence by giving here's a bullshit copy and here's a great copy. What more do you need to fucking see? I don't know. It's like, really. This makes lawyers look bad in general, because nobody does. Most people don't do this. There's been plenty of cases where I'm like, fuck, when I turn this over, it's not going to be good, but you still turn it over, right? You still turn it over. It's his right to have that evidence, right? It's his right to be able to prepare for me to go after him if I'm the prosecutor. It's not my right to hide it and pretend like it doesn't exist, or give you a worse copy so you can't see what the hell's going on. That's wrong. That's wrong. I don't care if whatever anybody, that's just plain out wrong. And our sister, and they know it. Prosecutors do it all the time to poor defendants. Listen, I didn't do it all the time. No, that's just not true. Prosecutors do not do this all the time. I was a prosecutor and I didn't do this. I didn't do this at all. I never did this once as a prosecutor. No, this is wrong. I didn't do this. And all the prosecutors I worked with never did anything like this. I've seen prosecutors give evidence when we know it's blowing up our case. Here it is, and let it go, right? Because it's not our job to hide evidence from the defendant. That's wrong. If they do it all the time, they are wrong, and nobody cares. Well, we care. We care, and we as the publisher care, and that's why this kid should be found not guilty, because we do care. What type of recourse is available for the defendant? Of course, is dismiss all his charges. Dismiss all his charges with prejudice. Don't even let the jury continue. But we'll see. We will see. Let's continue on with the Ahmaud Arbery case.
From the state.
I've talked a lot about citizen's arrest, and that being the defense in this case, but there
with prejudice.
hasn't been any evidence that anyone was making a citizen's arrest. Citizen's arrest was never said by any of these three defendants at any point
This
in time.
is the state's response
The
to the
evidence has been
defendant's,
presented
the last
is that
defendant's motion.
Mr. Bryan and Mr. Greg McMichael never once said we're making a citizen's arrest, that we're placing
She's
them under
attacking the
arrest for crime
citizen's
of this,
arrest.
that
Attacking
we saw
whether
him
they had
commit a crime that day.
Citizen's arrest, which is good.
That was
I would be doing
not
this.
it. It was all, we wanted to stop and talk to him, and then we wanted to detain him. In fact, Mr. Rubin said in his opening statement that the intent was to detain him so that the police could show up and do whatever they were going to do after the detention. It's not citizen's detention, it's citizen's arrest. So while he talked about that, that is really not something to be considered in a directed verdict
arrest.
motion. And just because a set of facts hasn't yet been specifically identically brought before a court,
Yeah, I know I'm muted. I'm saying I'm flustered by that motion because Binger has all the power, right? He's the prosecutor, he has all the power, he has all of this. And to hide evidence in this way is not only it's this kid can be, think about this kid can be going away for the rest of his freaking life, right? This kid can be going away for the rest of his life. He's 17. And you hide evidence for his defense. You try to violate his constitutional rights. And you do all of this for what purpose, right? It's not like this is personally going to affect the prosecutor. If he loses the case, so what? He goes on to the next case. It's not about this defendant. It's about the system, right? He's doing you. All right. No matter how bad you think this defendant is, the reason why you follow the rules is because the system depends on every single person within it following the rules. And if you don't follow the rules and you're trying to get convictions, then nobody has trust in the system. And that's what's going to happen now. Millions of people are watching this case. All these people here watching this case are interested in the Rittenhouse case. And when the prosecution does something like this, what it does, it makes it causes doubt to, like somebody else just super chatted. All the prosecutors do this all the time. Listen, when I was there, I didn't do this. The people who I worked with didn't do this. And I hope you guys believe that. And if somebody did do that, they were fired. I have seen 5 prosecutors fired for doing crazy shit like this. We don't do this. And hopefully, you don't have to believe me, right? You don't have to believe me. I worked there, but we don't do this. What he's doing is not what prosecutors do. And I hope people understand that this is not what prosecutors do. It's just not. They are ethical people. And what he's doing is, if what that motion says is true, because I saw it, he's not ethical. If the Rittenhouse case is dismissed with prejudice, does he still have some type of protection? No. Oh yeah, he's full double jeopardy. It cannot be bought. It's done. It's thrown away. It's done. It's done. But this motion has me really flushed. It's really shaken. It's really fucked me up. Because it's like, why? It makes no sense. It honestly makes no sense. And it just makes it's like Jesse Smollett. Why are you throwing away your life and career over some bullshit case, right? We all know it was self-defense. It was a loser. You tried, and if it's a loser, so what? I tried. It's and think about it. No matter what you think about the Trayvon Martin case, those prosecutors, no one ever said those prosecutors were unethical, right? Those prosecutors did the right thing. They knew they had a shit case and they tried it and they lost. So what? I don't know, bro. I don't know. Let's go back to the case. It really just bothers me. Nate, what about Cosby, Flynn? Yeah, that's what I'm saying. Those are instances, right? How many? There's thousands of prosecutors out there, hundreds of thousands of prosecutors out there. People bad, like this person is saying, David. Yes, there are prosecutors who do bad things, right? There are prosecutors who do bad things. Granted, but that's not all prosecutors. That's these prosecutors. These assholes are doing bad things. So, David, you're right. But that's why we have to always be, and that's why we got to stop playing in these fucking media narratives about this shit and just, what's the truth? The truth is this would happen. So let's get back to the case. I'm not going to speed her up because she already talks fast. So we'll just play it at regular speed and we'll catch up.
These sets of facts. No two cases are going to have the same set of facts.
But thank you, David. And thank you guys for the super chats too.
The fact that there is felony murder based on false imprisonment case law out there where someone has been
David, you're right.
Found guilty of felony murder based on false imprisonment.
It's insane.
Someone's been found guilty of a party to a crime based on aggravated assault with a shotgun. Someone's been found guilty of party to a crime for aggravated assault with a motor vehicle. Those cases are out there, maybe not with these specific facts. So that argument doesn't really hold water either. In this particular case, when it comes to Mr. Bryan.
Just to answer your question, yes.
And this will apply for
he doesn't
all
have
of
to
the
testify
charges here.
Because it's not
Again,
it's an all or nothing.
It's party to a crime.
So
and that means
Fifth Amendment privilege means he does not have to testify.
His statements to Agent Seacrest and actually at the scene to Officer Minshew were about, I thought they had done something, I thought I was trying to help them get this guy, false imprison this guy, capture this guy. And that was what his intent was. It was to falsely imprison this particular person. And he intentionally used his vehicle to go ahead and do that. Both on Burford, when he intentionally committed an aggravated assault, putting Mr. Arbery in reasonable apprehension of receiving serious bodily injury as part of his attempt to falsely imprison him on Burford. Those two things contributed to his death because but for those things happening, Mr. Arbery would still be alive. So it is, as the pattern charge will be given, his actions played a substantial and necessary part in causing the death because without him doing those things, Mr. Arbery would not have been trapped like a rat over on Holmes Drive between the two pickup trucks. As we noted before, malice chased him through the public roadways in the pickup trucks, tried to stop him, cut him off with the pickup trucks. He drove him into a ditch. He assisted pinning him between the two pickup trucks, trapping him like a rat between the two pickup trucks. Mr. Arbery had not threatened anybody, had shown no aggression. Mr. Arbery had no weapons. He was totally unarmed. And here, Mr. Bryan never called 911. He continues pursuing Mr. Arbery. Mr. Bryan never says anything on the recording. He pulls forward despite the shotgun coming out, despite the shotgun being pointed at himself, doesn't slam on the brakes, doesn't yell, doesn't protest, doesn't honk, just keeps driving forward, driving Mr. Arbery forward. He helped to get Mr. Arbery to this location by redirecting him up Holmes. The most important thing is when you have common criminal intent, and here the state's position is that as parties to the crime, there's common criminal intent to attack Mr. Arbery via false imprisonment, aggravated assault with the pickup trucks, aggravated assault with the shotgun, and false imprisonment ultimately on Holmes. And that common criminal intent to do all those things, not necessarily the conspiracy. I'm not talking about conspiring in advance and coming up with a plan as we sit around the kitchen table. We're talking about what they actually did, acted in concert with each other. The white truck came down Holmes. Mr. Bryan was going up Holmes. Mr. Arbery had already turned around and was running back, and the white truck passed him. Mr. Bryan did not abandon this. He turned around. He kept going, and then he accelerated to catch up to Mr. Arbery, passed the blue mailbox, saw the shotgun, and kept going. Common criminal intent, which resulted in malice murder, resulted in all the felony murders. All of his actions did substantially contribute to the death of Mr. Arbery, and they were necessary because without those actions, Mr. Arbery would be alive. We ask that you deny the directed verdict for all of the counts as to Mr. Bryan. Thank you.
Yeah, she didn't even go into the rest of his madness. She just
Any final word from Mr. Bryan?
Deny.
Your Honor, the state is constrained to acknowledge that they have no legal authority for their position, for example, on malice murder. Then I think the court should take seriously the motion to grant the directed verdict. There is no malice murder case against Mr. Bryan. With all due respect to the state, there never was.
Let me address this real quick. There wasn't false imprisonment. There was reasonable suspicion that felony had been committed. Again, we've been saying this as many times as people keep saying it. This is a fake news quote. I'm not sure who's telling you people this. But here in the United States, I'm going to put myself on screen. I'm not muted. I'm looking. I'm not muted. I got to put myself on screen. Welcome to the United States of America, where we have a constitution. And that constitution says if you're going to seize persons, right, if the state's going to allow people to seize people, if you're going to seize people, seize somebody's body, you have to have what's known as probable cause to make an arrest. Reasonable suspicion is for law enforcement to create Terry stops. There is no such thing as a civilian Terry stop, meaning a stop, question, and frisk based on reasonable suspicion. So the statute and in court, as we've been hearing from openings, from witness testimony, from the lawyers, the judge, and the defense and the prosecution, is that reasonable suspicion is not enough for an arrest. You need probable cause. And in this case, when we're talking about a citizen's arrest, they would have needed probable cause that a felony had been committed, not reasonable suspicion. So if people keep saying it's reasonable suspicion, I don't know where you're getting this from. I don't know why you keep saying this, but this is wrong. It's wrong in this case. It's wrong in the law. It's wrong in the Constitution. And when people keep saying it, I don't know why. So if you're going to come here and say this, just understand you're going to get checked, right? The United States Constitution and Georgia law demand that you have probable cause. And that has been said in this trial multiple times. The standard for a citizen's arrest has been said in this trial. The defense attorney who's representing these guys has said that in this trial. So, reasonable suspicion, no. Probable cause, yes. So if this is true, if they had reasonable suspicion, you are saying they are guilty of murder because guess what? Reasonable suspicion is not enough. Thank you.
There are some other issues in the case that are more challenging and more troubling. But that's an easy call. I think it's an easy call on count 2 felony murder for Mr. Bryan only. Again, the state has no, it doesn't even pretend to give an explanation as to how Mr. Bryan thinking that he's aiding a citizen arrest lawfully or unlawfully, how that translates into an intent to shoot or an intent to injure. And it's deeply troubling to me that the state can't have the candor to acknowledge to the court that maybe in retrospect, counts 1 and count 2, as to Mr. Bryant, were not well thought out. There's no proximate cause. There's no reasonable foreseeability here. I'm impressed with the argument that was made, but still, Mr. Bryant is entitled to a directed verdict, certainly on count 1, almost certainly on count 2, and arguably as to every count in the indictment. Thank you.
And Your Honor, I apologize profusely. I had pulled up the case and I forgot to cite it. And it is both the state of Georgia, Moore versus the state and Milburn versus the state. It is 311 Georgia 506. And in this particular case, a group of men wanted to rob a drug dealer, and one person stayed downstairs to keep the boyfriend away while they went up to go ahead and search the apartment. Unfortunately, the girlfriend was in the apartment, and the two that went up there, one executed the girlfriend. They came downstairs. The state obtained a malice murder conviction on the man downstairs who simply kept the boyfriend from protecting the girlfriend upstairs. And that is a case that does show someone who doesn't have their finger on the trigger, who's downstairs doing some other action, the same sort of criminal intent, which we feel that's here, same criminal intent to falsely imprison, aggravated assault with the trucks and
Thanks,
with the
Jennifer.
gun,
Thanks, I appreciate it.
can be convicted of malice murder, and that's the case we cite too.
I'm just trying to explain it.
Brought it up further earlier.
Sorry, was there a citation for Milburn, or are we abandoning that at this point?
No, Moore and Milburn are co-defendants, and it was a combined case, and
Okay.
so it is the same case. 311 Georgia 506 out of Cobb County, 2021.
Again, Your Honor, that case doesn't even get close here. That is in line with the other cases, what I call the distraction line of cases. It's basically the same thing. In this case, it's distraction plus, in that the person who's being charged is holding basically a third party who could otherwise and would otherwise go to the defense of the person who's killed. Mr. Bryan is sitting out there in his truck armed only with a cell phone. He's not holding anybody back. He's not saying, Mr. Albanza, you stay back there. There's nobody else on the scene. This is a case where someone is actively preventing this. Moore v. State is a case where someone is actively preventing a third party from coming to the aid of the person being killed upstairs. That is completely irrelevant and totally off base. And again, Your Honor, if that's the best the state can present to the court, then I think the court is constrained to grant the directed verdict as to count 1.
All right, I've heard the arguments and presentation of counsel on the motions for directed verdict under 1791A. The court, considering the appropriate standard after the state's rested, is denying the motions for directed verdict of the McMichaels defendants, the collective motion made by Mr. Hogue, as well as Mr. Bryan's motion for directed verdict as presented. The court also has the demur to address. So the court, having reviewed the demur, it looks like it does raise a slightly different issue than what had been presented previously in the demurs that had been filed, specifically the contentions that count 7. And this is paraphrasing, combines multiple violations or different violations under the same statute in a variety of ways with numerous defendants. This is the allegation. In such a manner that cannot be reasonably countered at trial. And I've reviewed count 7, which does apply to all 3 defendants. It's the aggravated assault. In this particular case, the defendants are charged as parties to a crime. having reviewed the language of the indictment itself, it is in the conjunctive. Court looking at cases such as Moore v. State, 319 Georgia App 696, and Straker versus State, 259 Georgia App 904, as well as Muhammad versus State, 307 Georgia 89. After considering the submission of counsel as well as arguments made, denies the demur. The next matter I have before the court is the defendant's presentation of evidence and choice to testify. So what I'm planning to do is get into Mr. Bryan's opening statement and then get right into evidence. I'm assuming we would start with Travis McMichael. I didn't know whether there was going to be a combined presentation. Has there been any discussion about that?
Joe, we're going to begin with our witnesses. And so to the extent that they serve both Travis and Greg McMichael, they may or they will. And I think that we will be handling all of the witnesses for that joint kind of presentation.
I was trying to think of how that then is presented as we get started with the jury.
And it would probably be something to the effect of we rest, and then if
the
Hogues need to do anything, then they could, or they would just say we also rest, and then Mr. Bryan.
Okay. That makes sense. I understand how we'll present it then. Then I guess with that being how we're going to move through this. Go ahead, Mr. Goff.
Your Honor, we do have two matters to put on the record before we.
Oh, here this guy go again. This is our boy. He's usually going to start talking about Jesse Jackson again.
What I'd like to do then is, has there then been discussion, counsel for Travis McMichael, about his right to testify and his intent with regard to testimony in the court?
Yes, we've discussed with him that he has the right to testify or not. He has expressed to us that he understands that very clearly, and he will elect to do so or not do so. The court certainly can inform him that he has the right and that he's presumed innocent and all that, but we discussed that with him.
No jury's in here right now. Directed verdict was denied.
Let's make sure he's
on
informed.
all
I want to
counts.
make sure he's
This is
informed.
going- yeah.
So generally what I'll do is swear the defendant in and walk through a few questions to make sure that I'm comfortable with his understanding of what his rights are, since it is his decision and his decision alone to testify.
Right.
So that's the court's general course.
So the directed verdict
We
has
can
been
do
denied.
that. I guess what you're saying is at this point, no
All charges are
decision's
going to
been
the
made, or
jury.
there has been.
We're asking the court not to ask him if he's going to testify or not, but the court can inform him of his rights.
Well, I might have to circle back then as we get into the evidence, just to make sure that I'm clear about where we are. But I would like to generally make sure that that discussion has occurred.
Yes, Your Honor, the same thing. We have made Mr. McMichael abundantly clear, and of course, he already was aware of his rights, the dangers, the pros, the cons, and he understands that it is his decision to make. But we would not be allowing, respectfully, the court to inquire of him of that decision until he's made that decision. He'll either take the stand or he won't.
I'll go over that when the break.
Court and the rest of folks what decision is made.
Well, I'm going to wait then to swear the defendants. My understanding, then the representative.
Thank you, Your Honor.
Understand that you do have a right to remain silent in this court.
Yes, Your Honor.
And what that means is that you have the right not to take the stand and testify, and nobody can make you testify in this court. Do you understand that?
That's correct. Yes, sir.
The right to testify in this court before this jury is your right, and therefore it ultimately is your decision and your decision alone, whether you do or do not testify. Understand that?
Yes, Your Honor.
No matter what your lawyer may have told you, and again, I don't want to get into any of that, ultimately it's your choice.
That's correct.
You understand that if you do testify, you'd be treated like any other witness in this court, which means that not only would you be able to testify on direct examination with your counsel, but you would be subject to cross-examination by the
Yes,
state.
they are denied.
Do you need any additional time to speak
That
with
means
your
they're going
lawyer
to the
about
jury.
your right to testify in this
They're
court?
going to the jury.
I do not.
Charges.
Thank you, sir.
Thank you. Thank you, Your Honor.
If they're dismissed,
Mr. McFarland. Again, I have no opinion either way. You understand
judge is
that. I won't
going
go
for
through all
each
that
defendant and let
preparatory
them
that I
know their
just did
rights,
with Travis
whether they're
McMichael.
going to testify. or not
Again, I'm just trying to ensure that you understand what your rights are before this court. With regard to your education level, what's your highest level of education?
Phone call.
And I understand you have already spoken with your attorney already about your right to testify in this court.
I have.
You understand you do have a right to remain silent, and that what that means is you do not have to take the stand in this court. I probably should have mentioned when I was going through this with Travis McMichael. If you choose not to take the stand in this case, the court will instruct the jury that they can't hold that against you in any way.
Now that's what's important, because that's what they're saying.
Again, lawyers, you've had this discussion with your lawyers. You understand, though, ultimately is your decision and your decision alone whether or not you do or do not testify in this case. And have you had a full opportunity to discuss the matter with counsel?
Yes.
Do you need any additional time to speak with counsel? Thank you, sir. Mr. Prime. Again, what is your education level?
12.
And again, you do understand that you have a right to remain silent in this court?
Yes, sir, do.
That you cannot be compelled to testify before the panel if you don't wish to?
Right, yes, sir.
You can testify before the panel. You understand that?
I understand.
And the decision to testify or not testify is ultimately your decision and your decision alone.
Yes, sir.
No matter what you may have discussed with counsel.
Yes, sir.
And did you have a full opportunity to discuss with counsel your right to testify before this court?
We have.
And you understand that if you do testify before this court, you'd be treated as any other witness, which means that the state will cross-examine you.
I understand.
And you understand that also if you choose not to testify, the court will instruct the jury that that cannot be held against you in any way. Do you understand that?
Yes, sir, I do.
Do you need any additional time to speak with counsel about your right to testify in this court?
No, sir.
Thank you, sir.
Thank you.
All right, Mr. Goff, you indicated you had 2 matters before the panel comes back.
Yes, Your Honor. Since we last broached the subject, I would note that an individual that matches the general height and build of Pastor Mark Baker, a local pastor, I believe in jury selection, he was referenced by one of the jurors or potential jurors.
Back to the pastors again.
Having had the Attorney General of Georgia, Chris Carr, as a guest at his church where this case was discussed. I saw what I believe was that young gentleman, a pillar of our community, I would add, in the back of the courtroom yesterday. And
what the hell does he keep talking about the people sitting in the
I
courtroom?
thought I saw him out in the hallway. I would also note
this guy is insane.
it's unclear whether he is a member of the Community First Planning Commission, one of the 21 black pastors. Of course, that is not just black pastors. There are other white pastors who've been in and out of the courtroom. I believe yesterday.
They had white pastors in the
Could be mistaken because I've never had the pleasure to meet her personally, but I believe our local rabbi, a white female, who's also been active.
the attack of the black
Social
pastors.
justice movement here, for lack of a better word, was present in the back of the courtroom.
Oh my God.
Given the court's rulings, and I'm not questioning the rulings of the court, of course, we're unable to document who actually is in the back of the public gallery, in the back of the courtroom. But then this morning, I believe, as much as I'd like to see him, I regret the circumstances. The Honorable Right Reverend Jesse Jackson is here yet again in the back of the courtroom. And there has been no indication yet from the state or anyone else that he is actually here in a capacity as a minister, given his remote location from this area. I am, again, separately and independently from any of the prior motions for mistrial, moving for a mistrial in this case. Again, the developments of yesterday afternoon and today, in conjunction with all that has gone before, reasonably called into question whether the defendant Brian can receive a fair trial in this matter, notwithstanding the best efforts of this court to ensure one. And we are therefore moving for, again, for a mistrial.
Anything from the remaining defendants?
We're not joining on mistrial, Your Honor, but I think that it's prudent to recognize the limitations that the court set for who will be sitting in these rows, and that we do have the overflow room for the general public. I think it's been made abundantly clear that the people who are joining the Arbery family are part of a larger conversation that is happening nationally, that has been funneled down into the community. And so they represent a national conversation that is for the conviction of the defendants. And for that reason, I think that they should not be present in the courtroom where the jury can see them and be reminded of the national conversation. That is an improper influence on the jury to the extent, and I'm sure that they would recognize throughout the course of their lives, that they have had this type of impact on communities nationally and locally. And for that reason, I think it's more prudent to have them join the public in the overflow public room so that the risk of influence isn't present. Thank you.
Greg McMichael joins Travis McMichael's motion.
That would be the remedy that we're seeking.
There's absolutely no evidence that these jurors are aware of any national conversation about the conviction of these defendants. So to say that this is having an influence on the jurors assumes facts absolutely not in evidence. The assumption that there's some improper influence because some people are sitting in the back of the courtroom, there's been no evidence of that. And we leave it to the discretion of the court, Your Honor.
All right. The court's denying the mistrial. I address Mr. Sheffield's point. During jury selection, these particular members of the panel, the entire panel, I should say, that was before the court over 3 weeks was extensively, I don't want to say examined because that makes them sound like witnesses, and I've equated that before, but they were asked quite a bit about their backgrounds as part of the vetting process for this jury. And in fact, a lot of that went further than this court may have thought necessary, but it did delve deeply into many beliefs that they have about what is going on in this community, as well as with regard to organizations such as Black Lives Matter and various other things. So that has been vetted through the court, and I'm comfortable that that process has resulted in a panel that is willing to listen to the evidence and only the evidence that is presented in this courtroom. I've already ruled upon the presence of certain individuals in the court. I'm not going to go back over that, but I'm denying the mistrial for the same reasons that I've done before. I will note that the court has put restrictions on what folks can actually wear in the courtroom. We're not doing any buttons or face masks or anything like that. Everybody is here complying with the court's orders. There is also a order in place that governs seating in the courtroom and seating in the overflow room. And as far as I'm concerned, that has been complied with. That's the court's order that I put in place about a week, maybe 2 weeks, could have been longer before the trial started, to help address some of the concerns that were voiced prior to trial. So since everybody's complying with this court's orders, and since the court is comfortable that we have a panel in place that will listen to the evidence that is presented and not be influenced by factors that may or may not be appearing in the courtroom. And I'll note, just so that it's clear, I believe that the Reverend Jackson is in the courtroom. With all due respect to whomever Mr. Goff was addressing before, I don't know who that is, but the court's position, I think, has been made clear. Are we ready to get the panel?
Not quite. The second motion, Your Honor. And that is a motion that relates back to issues that were discussed by the court with counsel before the trial started, I believe. And this motion is based on the developments during the trial of this case. We don't think the record is, at this point, adequately documents whether jurors have been contacted or otherwise exposed to improper influences. I think that it's probably at this point insufficient to just let the jurors bring matters to the attention of the court. It's probably something for the balance of the trial the court should consider inquiring on the record, or however we're going to do that to preserve the record. When we actually prepared the written motion that was filed on the matter the court's already addressed this morning, the ingenuity with which individuals over time, from the anti-civil rights organizations to organized crime, whatever. There just seems to be so innumerable ways to influence jurors. Sometimes they're not even aware of it. Sometimes it's not even clear till after the fact. We think the court, it's incumbent on the court to better document the situation with the jurors on a daily basis. And in support of that, I would start by go ahead and tendering as an exhibit. I was kind of surprised it didn't come up during Officer Rash's testimony, but he wasn't my witness.
What?
Madam Court Reporter can mark this as whatever exhibit next is for Mr. Bryan. I'm going to provide a copy to
Mark this as whatever exhibit.
opposing counsel. Hopefully there'll be one left for me when I'm done.
Look at that. He's like, what is this guy doing? Hopefully there'll be one left for me.
Your Honor, will recall the testimony of Officer Rash at the very conclusion. I believe it was the last question or two on redirect from Ms. Benikowski. She asked Officer Rash whether there was some litigation and whether it would affect his testimony. And of course, he said no. And of course, he's subject to recall, and whether we go back to Officer Rash or others go back in rebuttal, it's not for me to say. But there is, in fact, a federal civil lawsuit involving Officer Rash and defendants in this case, as well as District Attorney Jackie Johnson and Waycross District Attorney George Barnhill, filed by Wanda Cooper in her individual capacity as administrator of the estate of the decedent Ahmaud Arbery. That complaint, and it's copied, you're reading left to right instead of right to left on the page numbers, Your Honor. But basically, this is a lawsuit that spans 45 pages and approaching 300 paragraphs. Your Honor, it is a suit essentially making claims that are substantial. I would also note, and we certainly can try and print stuff online, I think it's pretty much common knowledge at this point, at least in Brunswick, that the 223 Foundation raised or claims to have raised $2 million for the estate of Mr. Arbery. I'm going, Your Honor, that there's
just like where we go with
this is a case in which there are a lot of resources out there.
What the hell's going on?
And there's a lot of things in play. And we think that, for example, the same lawyers involved in this case just settled for $27 million a lawsuit involving George Floyd. There's a lot of money floating around out there. And I'm not saying that anybody's using that money improperly. I haven't alleged that. But I am suggesting that under the circumstances of the case, that it would be appropriate to heighten at this point, based on the developments as the case has progressed, the court's inquiry or protection of the jurors from improper influence. I would note that none of us, including the state, no one has asked to sequester this jury. And I'm not asking the court to do that now, but we do have an unsequestered jury. And I think that under the circumstances, given the history in the George Floyd case, and I don't mean any disrespect to Mr. Floyd, I guess technically I should call it the Chauvin case, issues arose, things that came out after the fact involving, I believe, one of the jurors, issues involving elected officials, consciously or unconsciously, perhaps influencing a sequestered jury's verdict. I think there's enough basis in this situation, and given the developments during the trial and what is anticipated to be a massive event outside the courthouse in the morning, that the court step up the efforts taken by the court to ensure the sanctity of our jury process. These jurors have certainly never been exposed or involved in a case like this before. So I made my motion.
This is the same motion that was made by Mr. Hogue earlier in the case. The court initially indicated that we use that process, but the court and I informed counsel that I'd reconsidered that process and that I was comfortable with the way the court has been moving forward here, which is every evening before we break, making very clear and repeating the court's instruction with regard to any outside influences and asking that they be reported immediately upon their return. I have not received any of that from the panel, and the court's position remains that there are safeguards in place to ensure that that is not occurring. I understand counsel's concern, and that is the reason we're asking, or I'm telling them every night, what the court's specific instructions are with regard to any outside influence, discussion in the case, picking up newspapers, addressing social media, addressing anybody talking to them, addressing anybody actually speaking in their presence of hearing, and reporting that back to the court. That's why they received that instruction. So the court intends to proceed that way.
And for the record text, I don't think I tendered a copy of the federal civil law. So I gave it to the clerk, and I could see the blue tag on it. And Your Honor, the federal civil lawsuit has been tagged, identified as Bryan Exhibit number 51. 51.
Any objection?
That at this time.
No, Your Honor.
No, you're right.
I think you'd rather I give this to the clerk.
I need one more from Greg McMichael.
No objection.
Submitted. All right. Understand then, Mr. Goff, you ready for your opening statements?
I believe we are, Your Honor.
All right. Let's go ahead and get the pen.
Now, this is going to take some explanation, but
I'm going to remind them that you had reserved your opening statement to the close of evidence.
This one. All right. So in Georgia,
Bird cheese and share over there by the equipment.
just to let everybody understand, this lawyer didn't provide an opening statement with everyone else. He said he wanted to provide a statement after the state rested, just after they rested and after they proved their case, essentially. So now he's saying, okay, I'm going to provide my opening statement right now. So that's what they're going to do. The jury's going to come in. He's going to provide his opening statement. This is going to be a shit show. Let's watch it. This guy's hilarious. He's afraid of the black pastors. So let's see. Now they got white pastors coming inside there. They got everybody, rabbis. I think he's going to make his career off the black pastor stuff. He likes the black pastors. I'm trying to figure out what's going on with the Rittenhouse has just been blank all day. Trying to see if there's anything going on in Rittenhouse, but I haven't seen anything. Rittenhouse is just a waiting game.
It's all right for jury, please.
They're saying there's a verdict respected. I'm checking it out for you guys. Let me see if we got a verdict coming in. Hot verdict. Nope. Nothing. No verdict. Nothing. Got absolutely nothing.
Oh, we're missing one.
All right, please.
All rise.
All right. Good morning, ladies and gentlemen. I know you're back here at 10 o'clock. Thank you for your patience. We're just addressing some matters before the court. We are ready to proceed with the case. With the state having rested, Mr. Goff had reserved his opening statement on behalf of Mr. Bryan. So the next portion of the case will be the presentation of opening statement on behalf of Mr. Bryan.
Thank you, Your Honor.
Are we good? One moment, John. Oh, okay. One moment, Your Honor.
Good morning.
I think it's still morning. Good morning, ladies and gentlemen. As you know, my name is Kevin Goff. I don't represent any McMichael defendants. I represent Roddy Bryan, this gentleman over here in the corner. And opening statement is an opportunity for you to give a preview, or in this case, overview, of what we expect the evidence to be in this case. I know it's getting close to lunch. I'm not going to try and go into every detail. That could take all day. But I would like to highlight for you what we believe is some of the important evidence for you in arriving at the truth here and in arriving at a just verdict for Roddy Bryan. I'm going to begin from Roddy Bryan's perspective. And during our case, in our case, Mr. Bryan has no obligation to present any case. But during the presentation of our case, we expect to publish this exhibit to you, which you may or may not remember from earlier in the trial, or a portion of it. Roddy Bryan, on February 23, 2020, is working on his porch, front porch, minding his own business. And you can see Mr. Bryan there. Somewhere in that video, I can't see it right now, but there's a hammer somewhere behind Mr. Bryan. Matter of fact, you can just go ahead and play the video. You can see Mr. Bryan is working on his front porch. There's certainly no evidence that he's communicating with anybody else. There's no evidence that he's listening to any police scanners. There's nothing to suggest that he's participating in anything other than what it looks like. Repairing the front porch to his house. I can't tell if he's reaching for his hammer at that point.
We actually read it. We read it already. We read it on stream.
Oh, that's his tape measure. I'm sorry.
So. Thank you, River.
And at some point in this process, the evidence shows, and you can see how big the yard is, and it goes off to the side, and you can see a tree in his front yard that's providing a lot of shade at this point in time. Mr. Bryan catches out of the corner of his eye something that's different. And as he moves to get a better view, of course, he sees Mr. Arbery, and then he sees a truck catching up to Mr. Arbery. And there are words exchanged. Mr. Arbery, this is to me, this is important. The evidence does not show that Mr. Arbery has reached out to Mr. Bryan. You know, there's been a lot of talk about driveway decisions. There's been a lot of talk about assuming the worst in people. And at this time, we're going to pan to the still. And the still is going to be exhibit during the defense case. We'll be publishing this picture, which is marked as States 139. Now, we're not going to get into a big discussion about what Mr. Bryan does or doesn't know right now. The point is that as Mr. Arbery is running up to and past Mr. Bryan's home, this is, with all due respect, it could be something out of a Norman Rockwell painting. There's nothing menacing here. There's nothing dangerous here. Now you have to add in, this is a picture taken on a different day by law enforcement, but you have to add in Mr. Bryan, as you just saw in the previous video, working on his front porch. In this picture, the garage door is open. You can't see, but you do see in the other evidence in the case, Mr. Bryan's pickup truck parked in the driveway facing out with lumber in the back of it. And Mr. Arbery is the one who's coming up the street. Mr. Bryan's listening to music and obviously oblivious to what's going on that morning. Mr. Bryan has the opportunity before Mr. Arbery has the opportunity before Mr. Bryan even understands what's going on to say and speak out, help, call 911. There's crazy people after me. That doesn't happen. What Mr. Bryan sees from his front porch is an encounter that's, I believe, caught on the other Night Owl video.
They charged him with both.
As we do that, Mr. Bryan hasn't assumed, the evidence would suggest that Mr. Bryan hasn't assumed the worst about anyone, that Mr. Arbery, for whatever reason, has assumed the worst about Mr. Bryan. Because if he's in distress, if he, in fact, is feeling threatened, he has the opportunity to reach out to Mr. Bryan. The evidence would suggest, and you saw the drone thing yesterday, which for all its limitations, shows you it's a fairly big neighborhood. There's a lot of houses on this Sunday afternoon. There's no evidence that Mr. Arbery ever reached out to help, for help, either to Mr. Bryan or anyone else in that neighborhood. But from Mr. Bryan's perspective, when he sees Mr. Arbery come by and he sees this truck, and I believe the truck is visible in this video, he's responding to what he's seeing. And what he's seeing is someone who's not asking for assistance and not asking for help. Now, you know, there's been a lot of talk about folks in this case and their motivations. I'm looking at it from the perspective of Roddy Bryan. Roddy Bryan, the evidence shows, knows the people who run by his house because he sees them, 4 or 5 of them. But the evidence shows that he's never seen Mr. Arbery before. Now, to be fair, it's a big neighborhood. And intuitively, the evidence would suggest Mr. Bryan knows the difference between running to something and running from something. But in this case, there's really no mystery. But when Arbery passes Mr. Bryan's house, with all due respect, we know why. And I think that we can discern that from the evidence. Now, on the second Night Owl video, of course, you can see Mr. Arbery, stop there, or go back a second. Okay. Obviously, something's taking place on the street. And then what is Mr. Bryan's response? Because it's been suggested that Mr. Bryan is something other than who he is. And
The black
partly that's
pastors
based
are
on the
going
words that
to
Mr.
attack,
Bryan
huh?
himself uses, because he's not always the most artful. But I would submit to you that the videos don't lie. It doesn't matter whether Mr. Bryan said he was walking on one day or running the next. We can see from the Night Owl video that Mr. Bryan, I think as the police officer has acknowledged, is walking into his garage. Walking.
I did answer your question.
He's not running. And he does that. He does so without a weapon. He's got a hammer on the front porch. He leaves the hammer behind. He walks into his house calmly and he retrieves his keys. You know, actions oftentimes speak louder than words. And in this situation, the evidence shows that Mr. Bryan, in fact, had a rifle
Type
in
your question
his
again.
house
I'll answer it again then.
on the day
Type
of
your
the
question
shooting.
again. Sorry about that.
Mr. Bryan does not retrieve his rifle. He does not get his rifle. The evidence is that Mr. Bryan does not even possess a handgun, but he does possess a rifle. He leaves it. Nor does he go in the kitchen. He's not grabbing a butcher knife. He's not going in the garage. He's not picking up a machete. He walks out to his car with a cell phone and his keys. And that speaks volumes as to the intentions of Mr. Bryan on the day in question. Now, also, interestingly,
he didn't get
at
his
the very end of the video, I think.
So
I guess we'll just wait for Mr. Bryan to walk inside.
Let me just say something. He's throwing the other guys under the bus, right? Essentially, that's what he's doing. He's throwing the other guys under the bus. Hey, my guy didn't go get shotguns and pistols. He went and got his keys. That shows something, right? That means something. What does it mean for the other guys who are in trial? That means they were going to kill him. He's throwing his co-defendants under the bus. My God.
His house, and then he's going to come back out. And I think if you look at the timestamp, which we know timestamps aren't always accurate, but in this situation, in this case, we have no reason to question it. It takes approximately 13 seconds for Mr. Bryan to leave the lower right-hand corner, go in the house, get his keys, and come back out. Stop right there. And get into his truck.
I will. Now, somebody who asked me a question.
And I don't mean any disrespect to my client here, but it doesn't really matter whether Mr. Bryan says he's angled to the left, or he's angled to the right, or he's angled good, or he's angled not so good, or he's angled with more or less emphasis. We can kind of tell from this Night Owl video as to whether Mr. Bryan can accurately recall events, whether he can even do that on February 23rd. What do we know? When Mr. Bryan initially pulls up to the street, in fact, Mr. Bryan is angled to the right, away from Mr. Arbery.
They're all being represented by separate
any
attorneys.
Statement that's being put out there to
separate
suggest
attorneys.
He's angled to the left,
it's not
that's just not what the video shows. Now, he does pull back. Go ahead, you can play the rest of it. He pulls back briefly. Well, okay, and that's the end of it. But as he pulls back, he's straight in his driveway. That's what the evidence, the hard evidence shows. So people trying to suggest things or read things just into Mr. Bryan's words, my suggestion to you is your duty as jurors is to honestly seek the truth, to look beyond the words to the actual meaning that's intended. Now, I want to talk about the physical evidence in this case, because there's been a lot of talk or a lot of evidence or a lot of speculation about Mr. Bryan driving around the neighborhood. The physical evidence suggests, I would submit to you, that Roddy Bryan isn't out there like Evel Knievel. There's no evidence, for example, that he's tearing up his neighbor's yards. How do we know that? First, where are the pictures of all the damage done by Mr. Bryan's truck as he's going in and out of people's yards? There is no such evidence. Second, there's no evidence, and there will be no evidence, that neighbors complained or reported destruction of their landscape by Mr. Bryan. And that kind of makes sense. Anyone who's landscaped a yard knows how expensive that can be. And whatever has happened on February 23rd, and Mr. Bryan's been candid, he doesn't know exactly what's happened that day. But whatever's happened that day, if he's trucking through people's yards, tearing up their plants and their lawns, that's going to create its own set of problems.
This guy,
now,
I don't know where he's going with this. I'm sorry, guys.
We have I can't see it on these, and that's okay. But we have a deep, sometimes watery drainage ditch running along Merchant Burford. You do see it in some of the other videos that you've seen in this trial. And you hear about Mr. Bryan overshooting the road. The evidence shows another time he used the word crept out. Crept out good. Kind of hard to figure what that means, but what does the physical evidence tell us? Where is the evidence that Mr. Bryan left the road? We know that he said that he still had he could back up good. He still had his back tires on the road. We know that he didn't back down. He didn't go down into that ditch. However, active the tense or the wording that he's using, we know that he didn't, because there's no physical evidence, for example, that there's dirt or grass or anything on the underside of Mr. Bryan's truck. And again, we're talking out here where there's a ditch going down, and he's supposedly trying to run over Mr. Arbery. I think that's what the state tried to suggest. Where's the evidence that he did that? Because he somehow He's not running through the ditch, and there's nothing on the undercarriage of his car. Interestingly, I don't know that there's a single picture out there of the front of Mr. Bryan's vehicle. In an aggravated assault case where Mr. Bryan is supposedly trying to run somebody over with his truck, we have lots of evidence, lots of discussion about the side of Mr. Bryan's vehicle. I think there's one picture of the back of his truck and not a single picture of the front. Now, is there any evidence to suggest that Mr. Bryan's Chevy Silverado is different from all the rest? That he must have a Chevy Silverado, must be built like for flight or something, because it's all smooth on the front. There must not be a grill or a bumper or other things, because the physical evidence is inconsistent with what is being presented to you in this case. Context is key here. Does the evidence show, what does the evidence show? How hard can it be? Where is the evidence of someone who is evading and eluding who cannot go off-road? Is there any reason, does the evidence suggest that Mr. Arbery could not have walked off of the road onto a neighbor's lawn, onto Mr. Bryan's front lawn?
He's there. He's
practicing.
I don't
Is
know.
there evidence that he couldn't have stood behind a tree or so much as a mailbox? Does the evidence suggest that Mr. Bryan ever did or was even prepared to leave the path of the road, to leave the road? Is there any evidence that anyone did that or was prepared to do it that day? And, you know, let's talk some more about physical evidence. There's no evidence from Roddy Bryan's truck's computer system. You've heard testimony about there. We may hear more about it.
Oh, I don't know.
But you have heard
you'll see some. I think after Rittenhouse is done, you'll start seeing. I think Uncivil's going to come. I think
Mr. Bryan cannot know, for example,
some of them are going to be coming over here. But
Officer Minshew,
if they don't,
on the side of the road in the moments after the shooting, he can't know whether the computer chip in the truck has recorded the information. Obviously, that's something that
but they will probably
do. That's why the police looked at it. He doesn't know that. He doesn't have time in the seconds before Officer Minshew arrives on the scene to go be manipulating or configuring his motor vehicle's computer chips or the data that's stored on it. Where is the evidence that he even attempted to do that? Now, we know that it took months for the police. Evidence is that it took months for the police to go and examine that chip. And by that point in time, the evidence has been lost. But there's no evidence that that's the result of deliberate acts on the part of Mr. Bryan. But Mr.
All right, people, this guy is I don't know what this guy's even doing anymore. Right? I don't even know what the hell his argument is. So it is what it is. So it's about 12 o'clock. Unfortunately, I have children I have to pick up, and I thought we'd be going to lunch, but it seems like they're going to go a little longer than lunch today. So tomorrow we're going to pick up 9 o'clock, but tomorrow's going to be a full day. We're going to go all the way up to 3 o'clock. I'm going to put clips of this video. We're going to go over what happened this morning and this evening. I'll do a nice recap of that. We'll also do the recap of the Rittenhouse motion to dismiss, which I read here on stream. So that I'll take that and put those in separate videos so everybody can see those separately. So you can get the Rittenhouse motion to dismiss, which I think is very good. You'll get a little background on this. I'll cut the background thing up from this morning, and then we'll make for it. So I'm going to go because I got to pick up my kid from school. She got a half day today. And then tomorrow morning at 9 o'clock, we'll be back and we'll just do a full day of Arbery. The defense is part of it. Now, if something happens during the evening, I'll actually just do a recap of that. But I'm assuming that they're going to be going to lunch right after this guy finishes his opening, which is, I don't think he's going to move the needle any. So, all right. Well, listen, first, thanks everybody for the super chats. Thanks everybody for stopping by. Thanks everybody. And I hope you guys learned something. I hope this was both informative and educational, because that's what I do this for. And again, thanks for all the support, all the super chats and everything. God bless for those of you who believe. And I will be seeing you tomorrow, hopefully at 9 o'clock. If not, I'll be seeing you next time. Peace.